episode of Surviving the Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Good morning, good evening, whatever the case may be, wherever part of the world you are in. Welcome to Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. This morning, this is it right here. You're looking at the woman, Donna Adelson. Jury selection is now closer to 2 weeks away. As of this coming Tuesday, it will be 2 weeks. And she is now in the fight for her life. Of course, Donna Adelson is the matriarch of the Adelson family. She is the mother of Charlie Adelson, now a convicted felon serving a life sentence in prison for the murder of Dan Markel and a murder for hire plot. The government says that this woman here, Donna Adelson, helped orchestrate the murder for hire plot. She was arrested exactly 1 week after her son last November 13th at the Miami International Airport as she was trying to board a plane to Vietnam on a one-way ticket via Dubai. Highly suspicious there. The FBI, Pat Sanford, who has been on this case, was able to make the arrest just before she left the country on the literal jetway to the aeroplane. And so there have been multiple hearings. She was held subsequently at the Miami-Dade County Jail and then moved up to Leon County to Tallahassee, where she has been for the duration. We are going to see her via Zoom or live in the courtroom momentarily. Joined this morning by famed Tallahassee defense attorney R, the letter R and the O-U-R, our Timothy Jansen. Tim has his own law firm, Jansen and Davis, that bears his name. He does criminal defense. He was also a federal prosecutor for 5 years. This is our OG case. Tim, we're getting into the meat and potatoes this Tuesday. As I said, 2 weeks. I'm going to see you in 2 weeks for the trial. Tell us, what are we expecting from this motions hearing? It was described as the meaty motions hearing this morning. What should we be looking for?
Well, I think that the defense lawyers have to file certain motions to cover themselves. Some of these motions, there was one motion that I thought was well taken. A couple of the other motions are just fluff. They're just to cover themselves, to file the motions to make sure that they're for an appellate review or for ineffective assistance of counsel. They really have no chance of winning. He's not going to dismiss his case today.
All right.
It appears Robert Morris has been filing all these motions.
Yeah. Does he go by Alex or Robert? I know
he goes by Alex.
He does go by Alex. So we are getting to this right now. Donna's there. So
she is.
We're just efforting. COE, let me know. We're going to get the volume up here. This is off of a pool feed here, courtesy Law and Crime. But you can see already, we were told this was going to start a little late, but Judge Everett does not mess around. And we are looking at a video, Sarah Dugan in light blue, Georgia Kappelman in the green, Daniel Rashbaum in dark suit, speaking to Donna Adelson, who appears to be in a prison jumpsuit. They are working to get the audio, which we should be able to get hopefully momentarily. This all works on a pool type feed through the jail, through the court, I should say, itself. So COE and Space Coast are working, and we'll get that up and cranking, I'm hoping, momentarily. So just stand on by a couple of minutes, and we will get that to you immediately. So one of the things here, Tim, of course, is, does size matter, having to do with the courtroom?
Right.
3B to 3G. Charlie's trial, the proceedings were held in 3G, which is the bigger courtroom, but Daniel Rashbaum filed a motion to have this in a smaller courtroom. What do you make of this? Is there any chance that they move it to the tiny room?
I think it's a bluster. I think all the big trials we've had in Leon County have moved to that courtroom. All the sensational big trials have gone in there. I don't see any reason why they won't change it. It's better for security. It's better for the courtroom. It's better for the judge. Preseason's over, right? You look at the courtroom today. Judge is only handling this pre-trial matter. It's first on the docket. Sarah's been covering a lot of the motions. Today, George is there. She's dressed nicely in her courtroom attire. It's ready to go. Daniel's sitting on the inside of the bench, which means he's going to be the lead lawyer. He's probably going to argue most of the motions. And I think the judge is going to dismiss the moving because he's going to have to balance. The public has a right to come to see these trials. So hopefully we can hear.
Yeah, this audio is muffled, but we're going to try to fix this.
And also the proceedings as they unfold again. Please do not interfere in any way.
You're hearing some garbled audio here, but hopefully it will clear up. Space Coast is on it.
We're joining via Zoom this morning. Very well. To go through the motions that we're going to hear today.
Donna's gained weight.
Yeah. Again, we're just trying to fix the audio on this. Donna, obviously in the middle, it was unclear whether she would be here via Zoom or otherwise. Again, these are pool feeds coming to us, so hard to control all the audio. Someone noticing that Rashbaum has shaved his beard. This is true. Let's continue to try to listen in as Space Coast tweaks the audio best he can.
And look what courtroom they're in. They're in the big courtroom.
They're in the big courtroom.
Yeah.
And that was Alex Morris. They're going to fix the audio and get it right back to us. They are working behind the scenes, trust me, to get this fixed.
What he was doing was reading off all the motions he was going to hear this morning. That's what he was going through the list.
And tell us a little bit more about Alex Morris. People know Dan Rashbaum, now clean shaven.
Mm-hmm.
But tell us a little more about Alex Morris.
Alex is low key. Got a lot of trial experience.
In order of the day, everyone who speaks, speaking to a microphone.
So this is better.
Yeah.
Deposition, Sergeant Corbett's deposition.
All right, everybody, we're going to listen in here.
I think this was their best motion about Corbett.
Heels of that once we learned the information that was associated with his testimony and presentation.
Again, the different audio levels all coming from a stream, so this is a little low, but we're going to fix it all as we go here.
The state needs some time to prepare this as well.
I'm happy for it to be heard whenever it's convenient for the court judge.
So we can stay on our existing timeline of meeting the jury selection on the 17th. For now, let's tentatively schedule this for
This is good.
September 6th. Please consult with Lynn as to a particular time and courtroom. If I'm going to need additional time before we get to the 6th, I'll let you all know. Right?
This is on the motion on Christopher Corbett in a summary exhibit, I believe.
Include travel as consciousness.
Christopher Corbett was dealing with all the digital forensics. Is that right?
That's right. He made a summary exhibit that she's trying to use as a summary, which really isn't a summary. And the defense made some good motions on it.
This is Sarah Dugan. Let's just listen in for a few.
Thank you. One other matter that I wanted to address as well before we get into the argument of the motions. Mrs. Adelson, previously I have addressed with you
Conflict.
the fact that you are waiving any conflicts as it would relate to the representation of Mr. Rashbaum. Based on where we stand procedurally at this point, when you first gave this waiver, that was prior to there being any deadlines concerning discovery or being able to view the evidence that the state plans to present at trial. Now that there has been an opportunity by you to review this discovery with your counsel, I believe it is prudent to go through these factors again, ultimately to confirm that you still wish for Mr. Rauschbaum to act as counsel. If you please can stand and raise your right hand.
This is another protection the judge is doing to make sure this isn't an issue later on.
You're going to give it will be the truth. You can lower your hand. Mrs. Adelson, you understand that you have, under the Constitution, a right to conflict-free representation. Do you understand this, ma'am? Do you also understand as well that one of your attorneys, Mr. Rauschbaum, previously represented your son in a case or a similar case in this matter?
Yes.
Do you understand that he has a duty to hold in confidence certain aspects of that representation?
I understand.
Do you understand as well that this could create a potential or actual conflict as it relates to your representation in this trial?
Yes.
As to that conflict, do you realize, or I should say, do you understand that this could affect your defense in some way?
Yes.
Have you had an ability to consult with other counsel as to whether you wish to have a conflict-free counsel?
I'm aware of it. Yes.
And as to any potential or actual conflict that may exist with Mr. Rauschbaum's representation, are you waiving this?
Yes.
Thank you. You may be seated.
So you see, he's careful about conflicts. He's
Here,
preserving
I'm
the
doing this.
conviction, or if it's a conviction, but the
At this
trial.
stage, as we move
Yeah.
to trial,
Again, this is a pool camera, so this is the audio you're hearing is beyond our control. But Space Coast is a wizard at
state's motion, how this
clearing things up as the judge goes through this. A lot of people commenting about how Donna has put on a lot of weight. It appears she has. You can see no more hair dye. That's her natural hair color. She is shackled, feet and hands. She had trouble raising her right hand. Dan Rashbaum cleanly shaved. Alex Morris chewing on his glasses. Let's watch.
I don't know why they don't ask them to take the handcuffs off. That's if I was her lawyer, I'd ask the handcuffs to be taken off. She can't write notes and assist her lawyers.
Yeah.
Let's go ahead and start with the motion that procedurally bears on whether the case will move forward or not. The defendant's motion to dismiss the indictment for pre-indictment delay.
It's picking the easy ones first. The ones he's already made his mind up.
Whoever is arguing
Which was the first one? The motion to
Motion to
dismiss?
dismiss for delay.
Judge, may I approach the lectern?
You may.
I got it right.
Dan Rashbaum with a smile on his face. Here we go. This is a motion to dismiss because they took too long to indict Donna Adelson. Let's see what Dan Rashbaum has to say here.
The key thing is they have to prove substantial prejudice and bad faith, and I don't think they will be able to prove it.
Other than what's said, I don't want to repeat myself too much, but just to point out a couple things. Here, there are two components that need to be shown. You need to show prejudice. We need to show a delay, first of all. That's clear. I think that's clear on the facts. Murder was in 2014. Donna Adelson was a suspect in 2016. An affidavit was released in 2016 showing she was a suspect. You'll see the evidence in this case. We've had an opportunity to review the exhibits the state intends to present is the exact same, pretty much, evidence that existed in 2016, that existed in 2019 in the trial of the first trial, Catherine Magbanua and the others. So you do have a time delay. What we have to show is prejudice.
So before you continue as to that, and really all the details as to this matter, specifically, when are you alleging the first time is Ms. Adelson could have been charged?
She could have been charged in any time. She could have been charged in 2016, right? She could have been charged. They had affidavits for arrests of certain individuals that they didn't do in 2016. So she could have been charged in the first indictment of Catherine Magbanua, Sigfredo Garcia, and Luis Rivera. She could have been charged at any point in time from there on forward.
The reason I asked the question is because the motion makes reference to 9 years, but ultimately, when someone can be charged is when the clock starts ticking, at least by the logic of your motion, correct?
I mean, yeah, look, she could have been charged anytime after 2014, right? I don't know.
I wouldn't go that far.
I'm just saying, look, this is not, and to be clear, this is not a statute of limitation. There is no statute of limitation.
There is none.
So we agree with that. But she could have been charged any time after the murder. But what's clear is that the evidence that they're using today, they had in 2016, right? Much of the trial in 2019, 2022, and 2023 is the exact trial that we're going to hear in 2024. So the only new evidence since then is her trying to get on an airplane to go to Vietnam, which we don't think is evidence, right? So essentially, their trial is based on wires that existed in 2016, emails that they had in 2016, text messages that they had in 2016, right? And they certainly had it in 2019. So
Georgia should argue that Wendy's
9
testimony
years from, I guess, the
was
murder.
crucial to charging Donna, which didn't occur until after the trials. If I was Georgia.
Florida law, with the 11th Circuit law, certainly a time delay. Okay, so when you get that, then you have to look at the prejudice component, and you have to look first at the prejudice component. And you see here that because of that time delay, there are records that no longer exist that would show that she needs to defend herself against two of their main components of their case. So two of their main components of their case are going to be, and they're both brought in by Sergeant Corbett. Two of their main components of their case are call patterns, and I use the word patterns lightly, because in order to show a pattern, you need a length of time to show a pattern. So when they got call records, they got call records, I believe, starting in May of 2014 through July of 2014. So they got a very short period of time. Because she wasn't charged in a timely fashion, call records showing that there is no pattern, that this is exactly what would have happened earlier.
Joel, this is all conjecture. It's not real evidence. If he had real evidence and could get an affidavit that there was records that would say what he's saying, that would be evidence. This is conjecture.
Yeah. You also failed to mention jailhouse calls and hearing Donna's voice. So
that would take you back to 2019, give or take. And so we're able to not fully defend that point because the records don't exist anymore. That's prejudice. The second component are some text messages.
It's got to be substantial
We have
prejudice,
text messages where they claim
not just prejudice.
that she is outside of Charlie Adelson's house. We have to defend that. It's their one main piece of evidence. This is a premeditated crime they're charged with. Is there one piece of evidence after the murder? There's very little piece of evidence after the murder other than that and the wires. So the way to defend that is through SunPass records. Those SunPass records don't exist anymore. Now,
What is the record retention on the Sun bill?
3.5 years is what we're told. And that's what Agent Corbett testified to at the last trial. So, Judge, it's a predicament for us, right? Because understand that it is clear that, by the way, before 2016, just a month after the murder, the state pulled financial records for Mrs. Adelson. Pulled all of her financial records. They pulled SunPass records for other suspects in the case. They pulled call records for other people in the case. They didn't do so for Mrs. Adelson, and now those records no longer exist to defend ourselves. Now, the second component is a bad faith component. I think the prejudice component is clearly established here. The bad faith component, it's important to know that under bad faith, you do not need to show a sinister motive. The law in this court is clear, right? United States v. Foxman, 87 F3rd at 1223 says that bad faith in this context does not require a subjective, sinister motive on the part of the prosecution. That's important. Okay, we don't have to show that the prosecution did this on purpose. What we have to show is that they had a strategy, and their strategy was to wait. That was their strategy. Their strategy was to wait because they hoped that people would flip. And they kept on hoping that people would flip. They kept on hoping through the offers of immunity and otherwise that people would flip. And over time, they didn't flip. And so they waited. And because of that, we're put in a position where these records no longer exist. Now, Judge, we do argue in the alternative in this motion.
Alternative means I know I'm not going to win, but please give me this. Exclude the evidence.
They should keep out arguments of and admission of these pieces of evidence. Now, we're not arguing that they necessarily need to keep out all the call records, but they should not be able to argue that there's a pattern of calls. Because they can't establish a pattern because there's an earlier period of time that they have no idea what exists, and we don't have the ability to show it. With regards to the text message, we think it should be excluded. The SunPass records would clearly show whether Mrs. Adelson was at the house or not at the house. It would definitively show. Well, let me tell you why. Because you would see what SunPass records show back then, as they did now, is they show entry onto a turnpike.
Correct.
And so you would be able to see when she entered the turnpike.
Let me stop you there.
Yeah.
Are there not methods to travel and avoid the turnpike points?
Yes.
Where it might not be as direct, it might not be as easy, where if you enter the turnpike here, you have an easier point of access to drive, but ultimately, could she have reached Mr. Adelson's home and avoided the SunPass altogether?
Their record shows she did enter the turnpike. Their own witness shows that she entered the turnpike because he's got on his many charts where he guesses, he's got her on the turnpike through a cell tower. So you don't have to guess that she entered the turnpike. You know exactly that she did enter the turnpike. Their own records show that she entered the turnpike at what's called the Dolphin Expressway. Okay? So you go take 95 and you get on the turnpike at the Dolphin Expressway. That's where Dolphin Stadium is. You would, first of all, see on the SunPass the entrance there. And their records show that she's on that. Their cell tower records show that. Okay? Their cell tower records show also time frames on that same turnpike. Shows on their map, on their dots. They show her on the turnpike. What it can't show is if she got off the turnpike, it may not have shown her get off the turnpike, but it would show her get back on. So in other words, if they're correct, and she had gone to Charlie Adelson's house, which she didn't, but if they're correct, at some point she would have had to exit the turnpike. Okay? It wouldn't have shown her exiting the turnpike because when you exit the turnpike, it doesn't show you exiting. But they have her at a certain point in time back on the turnpike. They would have known when she got back on the turnpike and where. And that would have showed whether she was at his house or not. Definitively, it would have shown it. We wouldn't have to guess about it. It's just how the turnpike, it's just how the SunPass records work. It shows when you enter, and then it shows parts at the turnpike. So they're using a witness to make guesses. They have these beautiful charts where they have her pinpoint, and then they have Charlie Adelson's house, and they show that it could take from this time to this time, extra time, but they have no idea when she got off, where she got off, why she got off, and they would know for certain, 100%. We would be able to show for certain, 100%, if we had those records.
He doesn't know that. He doesn't know that. That's not true.
Moment in future argument about Sergeant Corbett, why are these not right topics for cross-examination?
Judge, clearly if they're allowed in, they're right topics for cross-examination, but you have to do a balancing test. This is the premier piece of evidence in this case. It is the number one piece
in his words
outside your house, because it is the only piece of evidence in this case, other than the wires, that ties Mrs. Adelson to anything.
And
after
paying Catherine McDonald.
It is the only piece of evidence. We have the wires speak for themselves. We have the checks that she wrote. We're not going to argue that she didn't write the checks. This is the only piece of evidence. And they're using conjecture to get it in where if they charge this case in a timely fashion, we would be able to show definitively she wasn't there. That's not our fault.
All right, let's go back to the U.S. Supreme Court case that is the genesis of this argument, Vasco. I believe Justice Marshall goes through the role of the prosecutor and their duties, and also discusses how the prosecutor has an affirmative duty not to charge someone before they have probable cause, to thoroughly investigate the case, and also not to clog the court system with cases they cannot prove. What is your response ultimately to this discussion as it relates to this case?
I think it's a very fair question. What you have to do is you have to then look at what has changed. So in other words, in doing that, that can't always be their answer. Right? They can't
So when he
tell you,
laughs and smiles, he's
how-
making things up,
what is
right? He's
changed.
finding time to come up with an argument.
And the reality is, when you look at this case and you see what is going to be presented, you have the exhibit list. When you look at the exhibit list for this case and you compare it to the exhibit list in 2019, it is essentially the same exhibit list. 2019, the first trial. I'm not even talking about Charlie Adelson's trial. It is essentially the same exact exhibit list. Their exhibit list contains, essentially, against Mrs. Adelson, emails that they had back then, wires that they had back then, checks that they had back then. That's essentially their case against her. Okay? So the reality is, when you're right. They should not charge people that they don't have probable cause for. But that can't always be their answer. They have to be held to ask, well, what has changed? You know, we asked a similar question in the last trial, and their answer was Dolce Vita. Okay, but Dolce Vita doesn't apply to Mrs. Adelson. She wasn't there, right? Everything that they had in 2000, and by the way, they had Dolce Vita, they just didn't have a clear version of it. The reality is, you're going to see that 95%, probably more, of this case that we're about to hear is the same exact case as it was in 2019. Almost the same witnesses.
Almost
the same evidence. It's the same case.
he's just not effective at all.
No.
And he doesn't come across confident.
This is not going to go well for him.
He's like a little kid arguing something, right?
Also, he keeps harping on the.
So as the defensive.
This is Sarah Dugan.
Yeah.
Test here for is going to be whether substantial prejudice is caused, not just prejudice, to the defendant's right to a fair trial, and was it the product of bad faith, so that dismissal is required. The two pieces of evidence that they talk about in their motion are the phone records and the sun pass. So I wanted to quickly go through each. For phone records, he says, well, you know, there are call patterns between the parties that occur on major events during the planning of this murder that the state presents. But every time we present this evidence, we also concede and present the fact that the people in this case, they all have relationships outside of any planning for this murder. Their boyfriend, girlfriend, their parent, child, they have children together. Those people in those relationships talk every day. That's normal and that's to be expected. And all these people do talk every day during the time that we have these phone records. Every time we've tried this case, the defense picks a random day. This is every trial we've had since 2019, I guess. Every defense attorney, picks a random day that summer and shows that, hey, there's also calls between these folks on these other days where there's not a trip to Tallahassee or some other big event in the planning of this murder, to show exactly that. They've done that every time through cross-examination, and they do that without having prior records prior to May of 2014. So there's no substantial prejudice to the defendant. And there's no bad faith here. Law enforcement subbed records beginning in May of 2014 because they were trying to get records from around the time the shooting occurred in July of 2014. So a little bit before. And then
Very,
also
very reasonable argument.
leading up to 2016, where there was no murder being planned at that time.
This is also much more coherent, just better laid out, this argument.
Are still in contact. They're still
And more
talking
credible.
all of those
Yeah.
records.
And a proper deference to the court.
Before you continue, is there a reason the records that are at issue in this motion were never pursued?
Because those are the times around the June and July trips where there was the attempt to kill and the murder of Dan Marpel. We have messages between them going back before that time, but we believed, or law enforcement believed at the time that they subpoenaed those records, that that was the most relevant time to the information in this case that would be relevant to this case.
Were any further subpoenas as to SunPass or phone followed up on once the state believed it did have probable cause against Mrs. Adelson?
I believe that after, so getting to the SunPass record.
They didn't get to Magbanawah
We
until she flipped. So they wouldn't have known she was going to say,
did, I think.
right? They had the email, right?
Mhm.
Once it came to light that, can I address the SunPass records and I'll let you know kind of what our tip was? Okay. All right, going back to the phone records, though, this is not substantial prejudice, and it's not a situation though where the state purposefully did not indict Ms. Adelson until she could not get these phone records anymore. So there's no bad faith in this case. It's not a situation where we purposely didn't indict her so she couldn't get that. Moving on to the SunPass records. First of all, there's no substantial prejudice that these records would be exculpatory. As the court pointed out, we don't know if there was a way she could have avoided that. We don't know if the exit or entrance even had a transponder in 2014. In fact, given that the defendant texted Charlie Adelson outside your house, and there was a witness at trial, Catherine Magbanawah, who said that the defendant had been at the house that night right before she arrived, we believe the SunPass records could very well be inculpatory. And there's no bad faith.
Good point. Great point.
Like the SunPass records too. We did, as the court asked, we had Jason Newland make a call to try to see if we could get the SunPass records. I believe it was last fall in 2023, but we also learned that they don't have them anymore this far late in the game. But the bad faith portion of this is only satisfied when the government makes a judgment about how to proceed with litigation to gain advantage over the defendant, and as a result, the indictment is delayed. The reason we didn't try to get the SunPass records earlier was because the state didn't really zero in on the fact that Donna Adelson went to Charlie Adelson's house the night of the murder until Catherine Magbanawah.
Exactly my point. Yeah.
In 2023, leading up to Charlie's trial and at Charlie Adelson's trial, Catherine Magbanawah mentioned that Donna and Harvey Adelson had visited Charlie Adelson's house the night of the murder.
Before we continue,
Yes, sir.
was this new information learned either through the proffer or trial preparation that had never been or never come to light before?
Yes, we learned that from her through her proffer and through information that she gave leading up to trial and her testimony at trial, which was all in 2023.
That kills the motion for the defense.
Obviously, Donna Adelson's phone locations, right, have always been in the records. The messages have always been in the records, but we didn't zero in on the fact that, hey, that's where this cash could have came from, and that was this relevant to the money drop, until Catherine Magbanawah said his parents had just been there right before I arrived. She said in her testimony that the money was there when she arrived, that it was damp. She believed Donna Adelson had washed the money. That made us zero in on the fact that Donna Adelson had been at Charlie Adelson's house right before she arrived, and that's when this money exchange could have taken place. After that, we began to look for evidence, that corroborated her statements. Leading up to trial, and we found evidence in the phone records that corroborates the fact that Donna Adelson did go by the house through her locations, through the message outside her house. But this wasn't a situation where we waited to indict Donna Adelson until some past records were no longer available. We would like to have those too. The Foxman case says that the defense says that this delay had to have been a deliberate act to gain a tactical advantage, and that's not what we have here. I also point out, Dan Rashbaum has said that he was retained in this case by Donna Adelson in 2016. Every trial that we've ever had has been, on YouTube, if anybody wants to see it. And they could have, if they believe that these SunPass records or phone records were so exonerating and obviously needed, those could have been requested prior to when they would no longer have been able to have been received.
Can the defendant, absent an active case in the subpoena of this nature?
The defense said in the last trial that he tried to get the SunPass records and he wasn't able to before we had even thought to try to get them.
Please continue.
I'm not sure when he tried to do that. Another thing here is that if the court denies this motion, I think at that time it would become ripe. The state would ask that the defense not be able to argue in opening or closings or testify in their own questions that, hey, because the defendant wasn't indicted until 2023, that means law enforcement or the state attorney's office didn't believe they had enough evidence. What anyone in law enforcement or state attorney's office thinks in this case is not relevant.
That's true.
Given that, we believe that, obviously the dates that law enforcement received evidence, the dates that, suspects were tried or convicted, those things are all fair game and can be pointed out by the defense. But not the argument that this delay was because the state attorney's office or law enforcement didn't believe there was enough evidence to convict.
So to summarize in a nutshell, the state did not even understand what it had in the way of a text message until Catherine McBanwell's proffer.
That Catherine McBanwell's information that she provided to the state really made us zero in on that and realize that money could have been exchanged at that time by Donna Adelson.
That's key. That's key for the get rid of bad faith.
Obviously, we always knew that they were traveling up to Tallahassee that night. The Harvey and Donna Adelson were.
After the murder took place.
Yes, sir. But Catherine McBanwell's information that we learned after her trial, when she began to cooperate and leading up to Charlie Adelson's trial, is what made us zero in on that.
Very well, thank you. Brief response, and then we're going to move on to the other motions.
Sure. Judge, I'll do the factual point first. I was retained to represent Donna Adelson in the late summer of 2016. Okay, so I think it was the end of July, beginning of August 2016, I was retained to represent Donna Adelson. The first trial happened in 2019. When that trial happened, we tried to get SunPass records. We did. We couldn't, because we weren't an active party. We didn't have any subpoena power.
Were you stonewalled by SunPass?
They told us, yeah, exactly. Okay.
They could have asked the state to get them as Brady material.
Was when Charles Adelson was indicted in the case. Then we were able to subpoena and try to get SunPass records. We were unable to do so because they didn't exist. So let me be clear on that. Okay. All right. The first time we were able to attempt to get SunPass records, they no longer existed. Okay. Now, with regards to them she makes a point that every counsel has picked a prior date. Let me tell you what happens. We did pick a prior date, but our universe for picking a prior date is like this big, right? And you'll recall at the last trial what happened with the prior date we picked, right? We aren't named prior dates. They found a court filing on that prior date. By the way, the court filing wasn't anywhere near the time of the calls, but they found a court filing on that prior date, and they made a big showing that this is another event, right? The reality is we want to find dates in 2013, in 2012, in January of 2014, in February of 2014. None of those existed because what they did is they got records only for a 4-month period of time. And any date that we pick,
as to that point, and I understand what you're getting at, but don't defense counsel in all manner of cases all the time say the subpoena was too wide, you cast too far. Meaning the murder what led before, what led after, there's really not a lot of argument as to the relevance. But if the state is seeking records of your client, or hypothetically any defendant, going back years in advance, are they really permitted to do that?
They don't need to go back years in advance, but they're presenting evidence in this case. Let me make 2 points to that. First of all, they got financial records years in advance. So if they got financial records years in advance, why didn't they get the same cell phone records years in advance? What's good for the goose is good for the gander. If he thought it was good enough to get financial records that far back, get the cell records that far back. Number one. Number two, they're putting emails in this case back from 2012. Why not go at least back to 2012 or at least back to 2013? They just cherry picked a 4-month period. And by the way, the records she talks about that come on later, they're related to the bump. They're not related to anything else. They're related to the bump. So yeah, they created an activity, and of course, that's going to create another pattern, right? The reality is it's unfair because they're making a pattern argument that doesn't, if it was a science experiment, it'd be a false experiment. Their sample size is too small. And we can't counter it because the records don't exist. And we don't need to show that they did it we don't need to show that they indicted her after the records existed. We're not claiming that that's what they did. They made other strategic decisions to delay her indictment. And those other strategic decisions had this consequence. Because of that, if you don't dismiss the indictment, you should not allow these records to come into evidence.
The judge is going to find no bad faith.
The effect of the proffer as it relates to the messages. Ms. McDowell's proffer, which was taken last year.
Of course, they had the message well before then. They had the outside your house message well before then. It's not, listen, when I saw it in discovery, which was before her proffer, I knew exactly what they were going to argue. It's very clear. You didn't need her crazy argument to know what they were going to argue.
Her crazy argument.
Well, let's look at this from the aspect of bad faith. Is it possible?
There is no bad faith.
Case file to not know what this one piece of paper actually means until a later date.
It is possible, but you have three, because there's been 3 prosecutors.
That's it.
Very fine prosecutors who have tried
If it's possible.
going into that case 2 times. So very unlikely.
The judge has already made his ruling.
Possible? Yeah, anything's possible. But it's not that hard of a message to figure out. You have one of the key suspects in the case who you've gotten other records for, communicating with another key suspect in the case, who, by the way, in 2019, their theory was the same, that it was a murder for hire done by these 2 individuals. You have those key, and you don't have many text messages between the 2. And you have one, and by the way, you only have like 3 text messages on the day of the murder. And so it's pretty hard to imagine that they didn't think a text message from mom to son on the day of the murder, on the night when you're driving up outside your house, 10 minutes is the response, was not an important text message. I mean, if you believe that, I don't know, Judge. That seems I'm skeptical of that.
Probably should have let Alex argue this motion.
Yeah, he's getting loud with the judge.
They didn't have the benefit of the proffer, but you should listen to that proffer because she doesn't talk about the outside the house message. And by the way, in that proffer, she doesn't even really talk about what they say she talks about. She did it on the stand, but she didn't do it in the proffer. That's not my memory of the proffer. She didn't say in the proffer that I don't believe that they had just left the house. That's what she said on the stand. They'd already put in the outside they'd already marked that as an exhibit. So, Judge, again, the standard is lower than what they're saying.
No, it's not.
It doesn't need to show that
Substantial prejudice and bad faith.
Past records didn't exist anymore. We're not alleging that.
Alex probably is wondering why he's sitting there.
Choices that then made it. Look, at the end of the day, Judge, what it also is you get to do a balancing test. And it's a fairness argument.
No, it's not.
Aside from everything else, it's a fairness.
Good point here by Alice Fell, by the way.
It was rooted in due process.
Yeah, it's a fairness argument.
I'm going to reserve ruling as to this.
So he's going
He's
to deny it.
Ruling, I'm going to review the trial testimony of Ms. McBanawan concerning the outside your house text message, as I believe it does give context to what is being argued in the motion by both parties. Right, let's move on to the defendant's motion to hold trial in courtroom 3B.
Does size matter? Courtroom 3G to 3B. Here we go.
Who's arguing this one?
And Tim, he said he's reserving
About this previous
Ruling till
for a
trial.
couple of practical reasons. You're going to be the best judge of what occurred during Charlie Adelson's trial and the interactions with jury and gallery. Essentially, this motion seeks a prophylactic measure against that. You're great at controlling your courtroom and being able to interact with
His demeanor is so much better.
But you still want a different courtroom.
Yeah.
it's a world of difference. World of difference.
Yeah.
He's
And
also
he's got a relationship with Judge Everett.
Fair enough. Judge, where we sit at council table there, the prosecutor's table obstructs the view of jurors 1, 2, 8, and 9. There's no ability for Ms. Adelson to view those jurors. There's no ability for the jurors to view Ms. Adelson or defense counsel. And of course, that's an important facet. Defense counsel sits here, displays here. Examining a witness, you park at the prosecutor's table, of course. Disconcertingly, in the last case, there were circumstances where communications between counsel and the defendant are posted on the internet before the lawyer can even get back to their hotel. And so it's been interesting to read the media response. This isn't a circumstance of trying to curtail the media's ability to gain access. It's a function of trying to facilitate there are fewer opportunities for problems to arise. It's a practical consideration. And of course, all of this is in your discretion.
Well, I was going to say, in researching your motion, I did not come across a fundamental statutory or procedural right to be tried in a particular courtroom. Do you have one to argue today?
No, I do not.
He doesn't.
It's a due process argument and a argument.
It's so much different, this argument and this lawyer versus Dan's presentation. Night and day.
I've tried many cases in the courtroom, multi-co-defendant cases in the courtroom. All of them are different. The acoustics in this room are rough sometimes. But from the number of inmates that we potentially have testifying in the case and the movements of people,
Yes.
it's not my challenge. It's the bailiff's challenge. There are security issues, and I know that it's difficult here. Courtroom 3B is smaller and more compact. I know that someone has mentioned that there are technological concerns of it being antiquated. No better time for us to ask court admin for an upgrade. We've got time to be able to put a machine in that works appropriately. There's really a functionality and a practicality argument to make sure that we best protect Ms. Adelson from things that we've seen occur previously.
Very well. What you raise about counsel table, when we do have co-defendant trials in this room, a second table is added. There's the defense's preference to ultimately have what would be considered as the co-defendant's table and face the jury for the duration of the trial.
I think
He's keeping it in that courtroom.
I think that we would.
He's giving them an option of turning their table.
One additional person sitting at counsel table with us during the trial. So there would be 4. So we'd have the traditional L, if you will, from whether it be in 3B or here. It's a little bit more difficult here because of the configuration to be able to put that many people. But to answer your question, yes, we'd like to be facing the jury, but 3B, I guess.
Very well. Response from the state as to this motion?
The state's probably not going to push too hard because they don't want to look like they're getting an advantage.
A letter was sent by the Martell family stating their reasons they wanted to remain in 3G. Did the court receive that?
The family, that's
I was
good.
able to review it. There were also some other letters that I received either from concerned parties that were forwarded I believe the state and defense as well. Did everyone receive the letters of the concerned parties?
Yes, sir.
You may continue.
Aside from those letters, just from the prosecution's perspective, the primary reason for us asking that it remain in 3G is just from a practicality standpoint in presenting the case. You know, in 3G, we have the big screen overhead. We have the multiple screens in the jury box for the individual jurors. We have an individual screen for the witness. In 3B, there's only one overhead screen that all 12 jurors will have to kind of squint to see. Also in 3B, the clarity of the picture on that overhead projector that from the big screen, and sometimes the sensitivity of the USB cord that's connected to your computer are a concern. Sometimes the state has to actually, wheel a TV down in that courtroom to use.
Don't bring up that
Very
television.
inefficient, and I know
You
the court knows.
know I hate that television.
Right, it's a pain. And so, being in 3G isn't just something that we do or we've asked for. In this case, we asked for it in all cases where we have a lot of visual evidence to be shown. In this case, we have surveillance video, cell phone records, maps, texts, emails, financial records with graphs and charts and electronic wire transcripts and other visual demonstratives that I think will be much easier for the jury to see and understand if the trial is in 3G. In the defense motion, they bring up, the inability to see the box that the judge has already, or as the court's already addressed. They also bring up the lectern placement as an optimal. I routinely will move the lectern with the microphone over to the projector so that I can operate the projector, or have my laptop up here on the lectern so that I can use my laptop and have it on the big screen so that I'm still at the lectern and not.
Sarah's very good,
out.
very believable,
That should
and
solve the problem.
confident.
With this lectern.
very competent, and she comes across great.
I want to point out that, the defense is concerned about juror distraction. However, in 3B, the jury box is extremely close to the gallery. So I think that there's a risk for distraction there as well. And I think that the court in the last trial, through instructions to the jury and through, making sure there was no cell phones used, was able to remedy that.
Very well. Prepared to rule on this issue today. I believe as the final jury instructions make clear, the jury will be instructed that they are to decide this matter based on the nature and quality of the evidence presented. The court is going to take all means necessary to avoid there being any distractions from persons present, sitting in the gallery, or attempting to improperly influence the jury in some manner. The examples that were cited by the defense, the court is not taking lightly. At the same time, the court does not have a way to ultimately prevent what is being complained of in the motion from happening in any courtroom. I'm going to be very diligent and also very thorough in the deployment of the bailiffs as it results in this matter. The court also will take all suggestion from the defense as it relates to the placement of the table, so the defendant can be clearly seen by the jurors throughout the trial. As to the placement of seating on the defense side, ultimately, any observers or onlookers in the gallery are going to be placed at least 2 or 3 pews behind the defense, so that way there can be no attempts to either photograph or record the defense's interactions with each other, with Mrs. Adelson, or attempt to get any snippets of papers or other matters. Concerning the media and also any onlookers, I'm really not going to get into why people wish to come, if they have a legitimate interest or if it's just a curiosity for them. The Constitution provides that the courtroom will be open unless there is a statutory or otherwise basis for closing the courtroom or excluding persons. The courtroom is considered open. However, the conduct of those persons, the court will closely monitor. Anyone who is acting inappropriately will be removed from the trial. If this even goes to the issue of contempt and trying to influence the jury in an improper way, believe me, I have no problem having them break out the handcuffs. You can ask around. The defendant's motion to move the trial to courtroom 3B is denied, and this is also for practical purposes as well. Courtroom 3G is the most recently renovated courtroom in the Leon County Courthouse. It has technology options that are unavailable in the other courtrooms, and it is also best capable of accommodating the needs of this trial itself. If the state can prepare an order or the defense as to the denial. Let's move on to the defendant's motion to suppress wiretap interceptions.
Tim, no surprise about the courtroom.
No, not at all. That's the best courtroom. It's the most updated and it's the best to use.
Definitely not going to belabor this motion. It is the same exact motion that was filed in the last trial. It was denied in the last trial. The only difference in this motion is we have a section where it shows that Ms. Adelson has standing to make this motion. So Judge, I'm just going to rest on the papers. It's a preservation motion. We respect your judge's ruling previously, and I don't think, unless you want me to answer any questions.
I don't believe the state is contesting the standing of the defendant to raise this issue, correct?
Correct, Your Honor.
Does the state have any additional argument to make concerning those?
Judge, I do have a couple things I think I should put on the record so we're not relying on your previous ruling in this case.
This is all for the record, this motion. Even Dan knew it was going to be denied. So.
Just for an appellate.
Right.
Situation.
As to certain findings or conclusions of law as to my review of Judge Hankinson's authorization, those to a certain extent I will be relying on, but I'll allow you to continue to make your argument.
Yes, sir. I just want to put a couple things on the record regarding the standard for, it's alleged in the motion that necessity is a standard, and truly that's not the case pursuant to Phillips v. State 346 Southern 3rd 1252. Exhaustion and the objective of the criminal investigation are the standard, and in this case we have met that standard by showing that other investigative efforts have tried and failed, or are too dangerous, or that this wiretap in this case was the most reasonable investigative technique under the circumstances. Regarding the objectives of the conspiracy in this case, the objectives of the wire in this case, it was to reveal the identity of the conspirators and their role in the conspiracy, so the structure of the conspiracy, and that's permissible under McGuire v. State 307 Federal 3rd 1192. That's a 2002 case. So here again, we're trying to identify the persons involved and gather sufficient reliable evidence to prove beyond a reasonable doubt what their roles are, what's the hierarchy of the conspiracy, is there any additional physical evidence that can be gleaned in this case, any information regarding monies or assets or other things of value. Regarding the staleness issue that's raised in the motion, I did want to point out a couple things. We note that the issue of staleness cannot be solved by a simple application of numbers of days without consideration for the overall particular circumstances presented in this case. Here, the circumstances of this investigation required efforts that involved a lot of record gathering and waiting for records and receiving records and analyzing them before we got to the point where we had reached exhaustion and were looking to seek a wiretap. The state subpoena served on 12/14 of 15 requested a bunch of records between 14 and 15. Those were received in 16, including this defendant's checking account. We then subpoenaed a bunch of different Adelson accounts, that, including the one that the checks came from, and those were not received until 3/1 of 16. So, that accounts for the timing. And there's a case that talks about, did I get it for you? Delay being appropriate in conspiracy cases, or more leeway being given in conspiracy cases because of the nature of the investigation. It's going to take more time. And I think that is
State v. McGuire, and Judge, it's U.S. v. McGuire, 307 Federal 3rd, 1192, and that's a 2002 case, which I already cited. Sorry to do that twice. But that case specifically talks about the government being entitled to more leeway in its investigative methods when it's pursuing a conspiracy, as it acknowledges that's a different type of case, different type of investigation. Lastly, Judge, I just want to touch on the issue of fresh evidence. As mentioned in the application for the wiretap, law enforcement anticipated the use of an undercover operative in conjunction with this wire, because in doing so would produce the fresh results, the chatter on the wire. And fresh new evidence among these co-conspirators. The chatter that occurred between them to handle the blackmailer was brand new communication that could only be intercepted using this wiretap. With this new evidence, the argument of stale probable cause becomes moot, because the new evidence was being created at the time that the wire was up and the communications were being intercepted. And there's a discussion of this fresh evidence and the importance of gathering fresh evidence in U.S. v. Maestas, Maestas, 2016 Westlaw 9725188. So that was all I was going to put on the record, unless Your Honor had some questions for me or wanted me to put anything else.
No additional questions. As to the application for the wiretap, did the defense have any additional exhibits that were previously not provided during the Charlie Adelson motion hearing or for this motion?
No, Your Honor.
No.
Very well. The court will file its written order in this matter. So let's move on from here.
Judge, can we just ask that those exhibits be incorporated in the record here?
Yes.
Thank you, Your Honor.
You see, Alex was making sure that the record included the exhibits.
Let's move on next to the defendant's motion to use a jury questionnaire.
Looks like Alex is going to pick the jury, I think.
Judge, the law says that it's discretionary. I think Judge Neff is doing one this week or this coming week, if I'm not mistaken.
Homicide?
Yes, sir.
That's another judge in this circuit.
Traffic from Ms. Gaston with respect to it. But the objective is for jurors to come in, not talk about, hey, what do you think that we're here for, and what's your opinion on what we're here for, and let's discuss the case. And if we're able to have them focus on the answers of the questionnaires and then submit it, the defense feels like we're miles ahead in terms of information gained, decreasing the possibility of tainting the venire or the pool.
Yep.
And being able to hone in quicker on issues. Now, all of the questions, Your Honor may take exception to some of them. The state may take exception to some of them. Some of them may need to be recrafted. It could be made shorter, but the overall goal is to see if we can get more information in the door before we have to start doing work with them.
All right. From the procedure that was used by both myself and Judge Wheeler, and I believe also Judge Hankinson, is there a particular thing that you're pointing to that otherwise negatively affected getting a jury?
I think there were instances have been brought to my attention, and I think it became evident in Charlie Adelson's trial that the jurors had been downstairs once they got up here. They had been downstairs, and that there was communication amongst them about the very thing that I was mentioning. Why are we here? What's your opinion on this?
They also did not remain.
I'm sorry?
They also did not remain.
Understood.
I'll put it this way. If you can't follow instructions at the outset, there's no reason to keep going with you. Yeah. If anyone that I find in that way,
you're unlikely.
We don't have to worry about them being on the jury, but go ahead. But
are there additional instances of problems? I don't I don't think my answer is yes, there are additional problems. I think it's a circumstance to be able to make it better and make it work more efficiently.
Very well. Response?
Judges really don't like jury questionnaires. They like to control it in this circuit. Other circuits I've had questionnaires, but they just don't like it.
Questionnaire, we think, we'd like to hear and see these jurors answering the questions that the court asked last time. Sometimes it's just as important to see like how someone answers the questions and their body language and what they say and how they say it, as it is to hear the words that they're saying. And so we'd like to not have one for that reason. Also, we just don't believe that it would save as much time and be as efficient as the defense thinks it may be. I think we have to litigate, well, what does it look like? And both sides are going to want something different. And then we've got 5 or 6 pieces of paper for each juror that the juror then probably ends up getting asked about anyway. So the state would object to it for those reasons.
She's so practical that you just want to believe her.
Yeah, that's crazy.
Rule on it now. The court is going to deny the motion, and again, looking at this on practical grounds, ultimately, there is going to be examination by the court on the issues of pretrial publicity and hardship to serve in a trial of this length. The ability to engage an individual denier with the entire venire that has been summoned will sufficiently accomplish the goals of the jury selection. Those parties will be able to follow up on the court's questions. Additionally, as well, as my memory serves from the Charlie Adelson jury selection, several individuals who either were going to be cause challenges or other issues were discovered, such as them seeking to gain admission to the jury, were thoroughly rooted out during the process. In that way, this will work the same for Mrs. Adelson as well. Anyone who is biased or anyone who is trying to gain access to the panel improperly, we are going to get to the bottom of it. The process has worked. I believe it will work again. All right, let's move on to the defendant's motion in limine.
So no juror questionnaire. That was second denial in a row. Motion denied.
Concerning pre-arrest silence. The motion indicates that the state is not opposing this. Does the state have any additional argument, or is the position changed?
No, sir.
Defendant's motion in limine is granted as to prong 1. As to prong 2, wealth evidence, you may make your argument.
Okay, Judge, as you may recall, the state intends to call Mary Hall as a summary witness. I say summary witness because in the past she's been an expert witness, but I don't think she's an expert. That's for another day. But as a summary witness to talk about wealth records, if you recall, they put in records showing the combined wealth of the Adelsons. They go through a bunch of accounts and they show what their combined wealth was. Judge, we think this is clear that under U.S. v. Bradley, that evidence of a defendant's wealth may be admissible, quote, when relevant to issues in the case, but that use of a defendant's wealth to appeal to class bias can be highly improper and can deprive the defendant of a fair trial. Okay, this is clearly coming in for that purpose. Their wealth has no bearing on the issue in this case of whether
Mary Hall is the
premeditated murder.
Financial auditor who would
no
speak to Donna's money trail.
To it that checks were paid out of the Adelson Institute.
That was going to be my first question. And as to your general proposition, I would say you're correct on the law in the same way. The jury is not to consider that a defendant is indigent and hold that against them.
Right.
It would equally apply.
He's going to lose this motion, though.
As it relates to the state's theory of the case, is there any relevant evidence of wealth that you're still disputing?
No. I mean, the argument in this case is that she paid for a murder, and that is not our dispute. I mean, we're disputing it was for a murder, but we're not disputing that she signed the checks. We're not disputing that the checks came from the Adelson Institute. And we're not disputing that $100,000 was paid to Catherine Magbanua on the night of July 18, 2020.
They're just generous.
We're going to admit all the facts that's bad for us. That's
Look,
coming
even
in.
I mean, I talk with Dan, but he does not believe this himself.
Was
No.
there other evidence as to transfers of
You
vehicles,
shouldn't play poker.
property
No.
that is alleged to have been given to Ms. Magbanua?
There's evidence of a car that was given to Ms. Magbanua that was in Harvey Adelson's name. We will not dispute that either. Again.
So again, it's just generally, these are wealthy people, not the specific matters that are being alleged a part of the conspiracy or payment for the conspiracy.
We're not disputing any of that. So and why do they need to show a wealth of millions of dollars? You know, and they spend a lot of time on it, millions upon millions of dollars. What is that relevant to?
They hired a hitman.
I don't think it survives 4.
They offered $1 million for him to give the kids up.
It certainly doesn't survive that.
Response, State?
I mean, Tim, he did just admit in open court that she was paying them. Was that a mistake?
No, he knows it's coming in.
Yeah, I mean, because okay.
I want to prove that this defendant had the means to make the payments that are alleged, to make the payoffs that are alleged, to buy
Right.
the cars, property, etc., gifts, etc., that are alleged to have been received by the killers. And it's relevant to show that they have the ability to make the $1 million proposed bribe that preceded
Exactly.
the death of Mr. Markel. It's important to show the means relative to the payoff. So they had, this was a drop in the bucket, right? That's important, I think, for the jury to understand the motive and the means and how this was executed.
I think she's right.
Very well. As to this particular point, it will be granted in part and denied in part as to evidence which specifically demonstrates that either Mrs. Adelson or one of the other co-conspirators used assets to pay Catherine Magbanua or other members of the conspiracy. The state is going to be permitted to demonstrate that evidence. As far as any general presentation, however, as to all assets of the defendant, that is where the line is going to be drawn. As to Mrs. Holt being examined on whether the defendant had adequate assets to otherwise participate in what would be called the $1 million bribe, or is alleged to be the $1 million bribe, the court will permit that. But again, just going into a general examination of all of their assets as to showing in some sort of way to create a wealth bias, the motion is granted in that aspect.
But how are they going to get around her fleeing to Vietnam and going to live there?
It will be used.
That's going to come in, right?
Has to.
Questions as
And that's going to talk about her wealth.
May I have a moment to confirm?
Go ahead.
They should ask her. I'm sure Sarah's going to bring that up.
We're not going to dispute the $1 million offer. In fact, we're going to bring it out. So
Now they've opened the door.
I don't think they can hamstring us by stipulating the things. We still haven't.
You don't have to accept the stipulation. I believe this much is clear as a matter of trial practice.
Let me just confer with counsel about the financial evidence and see if there's any clarifications needed.
Go ahead.
So if you saw Dan whisper to Donna when the judge gave him a slight ruling, like, yeah, we won that, and Donna gave a look like, great. You could tell by her body language.
Yeah. Yeah.
He clearly has the ear of Donna.
Yeah, but he
She's
didn't
not
win the
with-
important part of that motion. He lost the important.
If we're inquiring of the witness, Paul, about the time frame in which, say, the $1 million offer was being proposed, we would be permitted to ask the witness, what did you analyze? What did you look at? And did the defendant have the means to make that payment at that time? But we would not be permitted to say what was the bottom line in her bank account at that date.
Correct. That examination will be permitted. What would not be permitted is to say the defendant had $10 million at TD Bank on this date. I believe that's ultimately what the defense's motion goes to. Am I correct?
that's correct, Your Honor.
See, if I were them, I would argue, Judge, we hope you will readdress this because of Vietnam and moving and the telephone call about getting rid of assets. That's all coming in, Judge. That's going to have a bearing on her wealth, and we think that's relevant for the issue of her fleeing. So they probably should bring that up.
Your ruling, Judge.
Let's move on to number 3, hearsay testimony from Jeffrey Lacoste.
Okay, this one's a little bit more complicated.
Not as complicated as you think.
And Jeff, look,
In the last trial,
he's testified previously.
Yeah.
And you ruled in our favor. You excluded the hearsay testimony as being just that, hearsay testimony. Okay? And what proceeded to happen, as we all know, is the state then
Called Wendy.
question of this piece of evidence, of these statements to Wendy Adelson.
And then impeached her with
Adelson
Lacoste.
denied that she ever said these things, and then they were able to backdoor it in through impeachment.
Which is proper.
Well, I wouldn't consider it as a backdoor as much as, would you agree with me? There are often times when it comes to evidence, may not be admitted for one purpose, does not exclude its use in other ways.
I would agree with that statement, but I would disagree that it wasn't a backdoor. But nonetheless, that was that trial. This is different because the question to Wendy Adelson in the outset in that trial was about a statement that Charlie Adelson made. So it fit an exception to the hearsay rule, which was it was a statement of a party opponent. Okay? In this case, the statement, if they ask Wendy Adelson the question in the outset, it doesn't fit such an exception. It's not a statement of a party opponent. Asking Wendy Adelson what Charlie Adelson said is still hearsay because Donna Adelson is the party opponent. And it's not a statement in furtherance of the conspiracy because none of this had to do with any conspiracy statement in furtherance of the conspiracy to commit a murder. None of these statements are in furtherance of a conspiracy. So what I'm trying to say in short order is, number one, we assume you're going to rule the same way, that it was hearsay, and prevent it from coming in through Jeff Lacoste. And what we're also arguing is that it should come in through Wendy Adelson because that is also hearsay. It's hearsay because it doesn't fit an exception. That it would have in Charlie Adelson's trial. It doesn't fit that any exception in this trial. And so we're asking that it not come in at all. Now, when you look at the statements, they're all a little bit different. Buying her a television was cheaper than a hitman. That Charlie Adelson actually looked into possibly hiring a hitman. And then that Charlie Adelson described a dinner as a celebration. That's even after the murder. So that's even, and then Charlie Adelson kept large amounts of cash in his home, right? These are all statements that are hearsay, right? They're hearsay if asked of Jeff Lacoste, and they're hearsay if asked of Wendy Adelson. And as a result, they shouldn't be allowed to be asked or admitted.
Response from the state.
This was his best argument so far today.
I disagree, Your Honor. I think these are statements against interest. These are
One
statements.
moment. I need to remove some people from the Zoom.
Yes, sir.
Uh-oh.
Wonder what that's about. So this is also going out on a
Are in furtherance of a conspiracy, Your Honor.
courtroom Zoom.
Charlie is telling the main beneficiary of this murder that he's looked into hiring a hitman. That's in furtherance of the conspiracy.
Those are co-conspirator statements. It's a hearsay exception.
Statement that Charlie Adelson had, in fact, in the summer of 2013, begun looking into hiring a hitman to kill Dan Markell, and the cost was either going to be $15,000 or $50,000. One of the two, she said, as you will recall. How can that not be in furtherance of the conspiracy, right? If Wendy denies it, then it's textbook impeachment to call the person that she said it to indicate that she said it.
And that is your argument as to all 4 of the statements that are being highlighted.
Yes, Your Honor.
Well, I'll reserve ruling on this topic for now. I want to do some additional research as to statements in furtherance of the conspiracy. Let's move on to number 4. testimony from Wendy Adelson.
And Judge, with regards to number 4, the state's position may or may not have changed on some of these. I just want to let you know that at the outset. They let me know recently that their positions were possibly changing. So here we're trying to prevent certain statements, certain questions from being asked to Wendy Adelson based on relevancy grounds. So the first one is questions about her book regarding human trafficking. We can't for the life of us explain how that would have anything to do with Donna Adelson's trial for first-degree murder. The second one is Wendy's, the name changes of her children. There's never been any testimony that those name changes had anything to do with Donna Adelson. We don't know how that could have anything to do, again, with this case.
I agree on both of those.
Is Wendy's willingness to allow Professor Markel's parents to visit their grandchildren since 2014. These statements have nothing to do with this case and in fact are used to prejudice the jury against our client, even though it has nothing to do with her. And the fourth is, and it came up in the last trial, asking about the Florida grandparental visitation rights law. I think that is one that the state has agreed to not ask about, but they go back and forth, so I'm not sure. So, but I think that is one. Again, these questions have very little to no probative value, and they're done to prejudice a jury. And so under a standard of 403, they should not be allowed.
Good. Well, also one point with this line of questioning, I'll hear the state's position, but I'll make clear on this. I understand Ms. Adelson is a member of the bar. However, if any testimony is permitted on this point, she is not to be opining on the Florida statutes and the validity of. Is everyone clear on this?
Yes, Your Honor.
Go ahead, Ms. Copeland.
I think in reference to the book, this is the one I kind of flip-flopped on because I went back and looked at how it came up last time, which was that Wendy Adelson denied wanting to relocate, denied being disappointed about losing her motion in court to relocate. And that is, of course, the state's theory as the main motive behind this crime was that she was wanting to relocate to South Florida. And I thought at the time that testimony opened the door to her having written a clearly autobiographical book about a woman just like herself, married to a man just like Dan Markel, who's utterly miserable and stuck in the place that she's living in. So if the testimony goes that way this time, I can imagine a scenario where I might want to ask about that. I'm fine with approaching, if Your Honor prefers that, to see if we think we're there, where I can inquire about that. There's a high likelihood I might not want to inquire about it at all. So however you want to handle that one. In reference to the other two items, I think those go to the state's theory that this crime was done in order for Wendy to move to South Florida with these boys and to erase their father and his family from their lives. And there's a lot of evidence of that, and that's part of the failure to provide access to the children to his grandparents and the name changes. So these kids were 2 and 3 at the time, and it's the state's theory that the effort was to eliminate their father, not just physically.
Right. As to that point, Ms. Kappelman, I understand the relocation and the divorce proceedings as it plays into the state's theory. But ultimately, was it not Mrs. Adelson's right as the parent and guardian of the children to change names or make certain parental decisions after the other parent has deceased?
Absolutely, Judge, but those decisions might be relevant to the state's theory in the murder. I'm not alleging that she's done anything illegal, but I think it's relevant to the consideration of whether or not this murder was done. It's inconsistent with what you would expect a parent to do on the heels of the murder of their father, right? So I think a reasonable juror could infer something from that and should be permitted to do so if they find it compelling.
Any further arguments to this issue?
No, Your Honor.
Just one briefly.
Go ahead.
Wendy Adelson isn't on trial. So, I mean, this may be a different topic if this were the trial of Wendy Adelson, but this is the trial of Donna Adelson. And what they're trying to do is they're trying to dirty up Donna Adelson based on decisions, either fair or not fair, that Wendy Adelson made. And again, that is, again, it doesn't fit, I don't think it fits the relevancy standard, but even if you get there, when you do a balancing test, they're going to be able to show, and they're going to do a pretty good job of trying to show what the divorce situation looked like and how Donna Adelson wanted relocation. I mean, they're going to be able to do that. So just adding this to the fire is, if in any way relevant, is when you do that balancing test, I don't even think it's close, Your Honor, for any of these conclusions.
Very well.
You'll probably reserve.
Prongs 3 and 4 of number 4 of the defendant's motion in limine. I will grant that as to prongs 1 and 2. I will give additional consideration to the argument that's been made. I will reserve ruling as to those sub-prongs from now.
Thank you, Your Honor.
Let's move on to prong 5, jailhouse recordings.
So I think this is pretty straightforward, Your Honor. We're not suggesting that Donna Adelson's statements, whatever recordings they might use, and we have to look at the recordings, obviously, but we're not suggesting that Donna Adelson's statements don't come in, but Charlie Adelson's statements don't come in. It's hearsay, and it's certainly not in furtherance of a conspiracy. This is after his conviction. So we're only talking about, let me be clear.
Well, I would argue the opposite. It's covering up the crime. It's still part of the conspiracy.
So there are recordings.
Yeah, I don't fully understand that.
Yeah. The state intends to use. I don't know. Where there is a conversation between Donna Adelson and Charlie Adelson. Donna Adelson, provided they meet other requirements, Donna Adelson's statements are not hearsay. They're statements of a party opponent. There's an exception to the hearsay. It's not hearsay, but Charlie Adelson's statements are just black letter law hearsay. They're not in furtherance of a conspiracy. It's after his conviction. I don't know how they could be in furtherance of any conspiracy.
Cover up is still part of the conspiracy. He doesn't know the law.
Are any of these in any way tied to this issue of travel as consciousness of guilt?
Some of Charlie's statements, no, I don't think so. I think they're tied to, well, I think there are statements where Charlie is talking about his trial, and Charlie is talking about why he believes he was convicted, and Donna is responding. The way she responds, I think, is allowed in. She may then respond in part about travel. I don't know. I'm not sure what they're using, but Charlie's statements are not admissible.
Right. State response.
This is a funny comment right here by Lord Pender, hoping that Wendy hears it.
Statements against interest that are made by Donna Adelson or are adopted by Donna Adelson in a conversation on a recorded line. We're not going to be able to extract one voice out of a conversation and only play half the conversation.
What is the subject matter of what you seek to admit in this way?
Well, we're talking about a few things. One call is the open line call, which I think Your Honor will know what I'm referencing. Maybe you're going to have to listen to these, but there's a call where
This
Charlie
was on the loan application.
Yes, Charlie actually drops off the call. So we would want to play a few statements of Charlie just to show, like, this is what's happening. It's a call where he's dropping off. She's, continuing to talk in the background. So I'm not sure if that's the one we're talking about or not, since Charlie's not really featured on that call. There are a couple other calls where the nature includes some of the talk of fleeing, relocating, committing suicide, and those types of things. So maybe those are calls that need to be provided to Your Honor to make a decision.
That would probably be best before I rule on this.
Mm-hmm.
Yes, sir.
Also, as to this point, and I believe there already is a standard jury instruction, as it relates at least to law enforcement and a defendant's interview, is your argument essentially this goes to the context of the call?
Yes, context, admissions, context and adoptive admissions in some instances, yes.
Very well.
He's going to let these calls in.
He is.
I can actually make a ruling on because
He
as the
will.
defense has noted, this is a call between Mrs. Adelson and Charlie Adelson about the quality of the food at the jail. We have hearsay problems and we have relevance problems.
Obviously must be good.
Anything the state would be seeking to admit is going to meet a relevance threshold from there, whether playing the entire context of it would otherwise get over the hearsay issue. That I still need to determine. If admitted, though, this would be subject to a specific limiting instruction. I have given instructions in other cases concerning the use of context in a recording. I will read the sample instruction to the parties. You also may propose any suggestions if it is admitted, but ultimately it would be, members of the jury, you're about to hear statements from co-conspirators or co-defendants of the defendant. These statements are pertinent only to explain the reactions and responses they may elicit. You are not to consider these statements by any co-conspirator or co-defendant as true, but only to establish the context of the defendant's reactions and responses. That ultimately, if any will be admitted at all, that will be subject to that instruction to the jury. So it is clear, Mr. Rauschbaum, that nothing of a non-party is being admitted for the truth of the matter asserted. What?
What about the consciousness of guilt? Isn't that motion?
Photos.
So Judge, the Florida Supreme Court has held that autopsy photographs are admissible if they are relevant and not so shocking in nature as to defeat the value of their relevance. But to be relevant, a photo of a deceased victim must be a probative issue that is in dispute. Okay. In this case, there is no dispute as to Professor Markel's death or the means that he was murdered. There's no dispute as to that. In the last trial, and I might be wrong about this, I think I was kind of conservative, 10 separate exhibits, 2 x-ray images, 8 photographs. I mean, it's clear what the state is trying to do. We understand they have to meet their elements, and one of the elements is to show that he was killed. That has never been in dispute. We understand Old Chief. We understand that ruling as well. But Judge, we would ask that these autopsy photographs be limited. That's our request.
Although I believe, I'm not certain if any of these were used during the examination of Mr. Rivera, but doesn't the examination of Mr. Rivera in some ways coincide with these photos, at least as to how the murder was carried out itself?
I mean, they weren't used with Mr. Rivera, I don't think. They were used with a medical examiner, and they were used in closing arguments. I don't know that.
Well, if they're entered in evidence, you can use them in closing.
Balancing test. I don't think anyone's disputing how the murder was carried out. There's no dispute. I mean,
No, not that he was shot, but ultimately Mr. Rivera's details of what actually occurred as it relates to his credibility as a witness and explaining other aspects of the conspiracy.
they haven't done that in the past, but we're also we don't intend on attacking his credibility when it comes to how the murder was done.
State, you may respond.
Yeah, they don't want these photos because they don't want the jury to realize how bad that he was killed, what their conspiracy was.
Material issue, it's required to prove that victim is in fact dead. We don't have to accept a stipulation. The photographs are what they are. We entered 8 photographs, which is relatively few for a homicide case. 2 of those photographs were x-rays, so not inflammatory in any way. One of them is an ID photo, and one of them is a photo of the stippling on the victim's arm. So that leaves 4 photos that are the type of autopsy photos that we think of as standard autopsy photos that show some gore. None of those are even internal. We're not seeing a scalp peeled back or the head open or anything like that. So I think this is a situation where we don't need to limit any further what the state has already chosen to introduce in this case.
Just
Yikes.
so polished and professional.
Yeah.
Right? What a
Scalp.
difference.
They're
Photos are probative. And the prejudicial effect does not outweigh them. The motion is denied as to this particular point.
yeah.
Let's move on to the defendant's motion to preclude traveler's consciousness of guilt.
I can't wait to hear this one. I take it that's going to be Dan and not Alex. Alex probably says, you take that.
Going to the spa. She was going to the spa in Vietnam.
Yeah, Alex says, I'm not, you handle that one.
Judge, I think our motion to some degree speaks for itself.
Which is badly.
He's going to say she was investing in a villa.
The state,
He doesn't even want to argue it.
this means to try to wait to arrest Mrs. Adelson until she tried to step foot on an airplane. Their argument is going to be, we believe that suggests flight, and that the flight suggests a guilty mind or conscience. However, we cited some cases, albeit not in
Florida. They're in Mississippi.
Find similar fact patterns in Florida. And we did cite the standard for the 11th Circuit in our papers, which spends a lot of time talking about the passage of time, which I don't think we need to reiterate again.
No.
I think we've beat that to death today. But the cases are interesting. When I started to look at it, I was kind of surprised, but it got me thinking. And I'm not a judge, as you know, I'm far from it. But I started to think, if I'm deciding this decision, what am I really thinking about with consciousness of guilt? And I'm thinking, well, did the activity that the person did, can I imagine an innocent person doing that same activity?
No.
In other words, if an innocent person would have acted the same way, it probably doesn't go to consciousness of guilt. And I think that's a simplified version of those cases, those couple cases that I cited.
Because if they're innocent, they're innocent.
Here, you can add that to the actual facts in this case, which shows that she wasn't fleeing. What you're going to see is that she didn't hide her travel. You're going to see that she applied for a visa with the State Department. You're going to see that she spoke openly to friends about it. In fact, friends booked her trip. You're going to see that she spoke to her lawyers about it.
I wouldn't bring that up.
To make sure that she wasn't
Oh my gosh.
You're going to see that she used her
His own conflict. He brought it up.
You're going to see that her passport was in her own name. You're going to see that she booked a hotel. You're going to see that she went to her own airport. She didn't fly to Mexico or fly to San Antonio, walk across the border.
That would have been smarter.
You see that everything was pretty open and notorious, things that would contradict flight. And so,
Let me stop you there.
yes,
Does flight have to be surreptitious?
No.
it doesn't, but when you're doing the balancing, again, it's all balancing, looking at the totality of circumstances. When you're determining whether it goes to consciousness of guilt, flight is a component, right? If for instance, it's surreptitious, well, that would be an argument in favor of the state as to why this would go to her consciousness of guilt. So the straightforward answer to your question is, no, that's not a requirement, but it's one of the balancing things when you're looking at the totality of circumstances. So when you look at the totality of circumstances here, you don't see surreptitious flight. When you look at the totality of circumstances here, you see that this is occurring many, many years, whether we say 9, whether we say 7, after she's a suspect. You see that she's traveled many, many times and always come back, right? So, and by the way, you hear phone calls. Their phone calls, the ones that they're mentioning now, where she talks about it, and when she talks about why she's going and what she's doing, right? And so, look, consciousness of guilt is a very, look, this is going to be, I anticipate, one of their prime arguments in this case, and it's a red herring. And so it should be prevented based on the totality of the circumstances and looking at that 11th Circuit standard. I don't think there's much more else for me to say unless you have questions.
No,
But
no more questions.
I'm here.
Well, is there any other evidence that puts context on this travel?
Is there any other evidence?
Any other reason why she was going?
Understanding what you're asking me.
Meaning, were there internet searches? Was there some sort of research about extradition?
Sure.
Are there things that otherwise go to, this is not just the purchase of a flight?
Sure. There are pieces of
Non-extradition country.
Yeah.
that I believe
Googling extradition, non-extradition.
try to admit
Getting her affairs in order.
both discussion and possibly documentary evidence of looking at places where there are no extradition. Yes, there are evidence of that.
There you go.
That-
Oh, Alex got in his seat now.
Alex
Hey,
is
man, you're killing us. You're killing us.
there is evidence of that for sure. But again, that's part of the totality of circumstances. There's explanations for that also as to why that doesn't show that they're going to become fugitives and
He can't even keep a straight face. Look at him.
Yeah.
Harrison Ford.
Harrison Ford running around in Southeast Asia for the rest of their lives. But
Oh my God.
we think that when you do your balancing test, prejudice outweighed. We'd also say this, and this my colleague brings up this point. It also leads to a variety of other issues. They have an appointment book, for instance, that they recovered when Mrs. Adelson was arrested that talks about a Vietnam villa and payments for a Vietnam villa, right? Well, that can be taken out of context as well. That Vietnam villa is an investment done, as they know, they've spoken, it's their witness, we've deposed them, with an individual named Scott Radius, who lives in Singapore. That individual had an investment with Charlie Adelson in a villa that, by the way, is sand. It isn't even built, and when it is built, they can spend 6 days in it. That villa.
That's under the rules of Vietnam.
No, it's like a timeshare.
Everett's laughing.
Even when you own it, you can.
Who
only-
thought
Yeah.
Harrison Ford would come into this
So when
trial?
Charlie
Right.
was arrested, Donna
Everett knows what this is.
continue to make payments for that villa.
Nonsense. Absolute nonsense.
With Scott Radius, and if not, they lost the prior payments. It leads to look. This consciousness of guilt argument leads to a lot of nonsense. To be honest with you.
I just said it was nonsense.
When you do the balancing test of the totality of circumstances, that it shouldn't be allowed in as consciousness of guilt. And at a minimum, if it is allowed in, we'll probably ask for some sort of limiting instruction. But Judge, we think that it does fit, the case law. Nothing binding on this. I mean, I think the case law of the 11th Circuit is very clear. It's in your discretion. But we think that given what they've done and the importance of this evidence to them, we think that when you do the balancing test, it fails.
That's a very damaging piece of evidence.
Yeah. I mean,
that's gonna
Tim,
come in. Yeah.
It's almost like he's begging.
He's
and
doing
he's
it for
all
the
over
record.
Wouldn't it be better to just be
Factors
succinct?
That suggest
He'd better let Alex argue it.
was a matter that was demonstrating consciousness of guilt as the ones that they planned to argue. She was just going on a vacation. She got an urgent emergency visa and bought a one-way ticket to what she had researched to be a non-extradition country. State feels that's relevant. If it's anything that the defense wants to argue and the facts that they've pointed out they're fair game for cross-examination. They're free to elicit those, and we can have a dispute. and let the jury decide what the evidence shows and what the weight is rather than the admissibility. But
I think
how is it
that's-
a 403 problem if she's just going on a vacation and that's what they're going to show? What's the prejudice if she's just going on a vacation? Problem for them is that there's plenty of evidence showing it wasn't just a vacation, it was something else. There is evidence of fleeing, and that's what we're entitled to show.
As to this motion, I am prepared to rule.
Let's go to the
Cases cited by the defense within its motion, and also looking at this as a matter of weighing prejudice versus probative value. The motion is going to be denied. I do believe this is a matter that goes to weight versus
not admissibility, right?
The finder of fact, the jury is going to determine whether Ms. Adelson was in fact merely researching a vacation, or if she was in fact seeking to avoid prosecution, or this is consciousness of guilt. Really,
God.
not for the court to exclude, as it is relevant and probative. As far as any limiting instruction that defense would seek, you may submit that concerning this issue. Right, I believe that covers the defense motions for today.
Wow.
Rush, Rob, if you can submit orders, at least for the matters that have been ruled upon concerning these matters.
He's pointing to Alex. Alex, you do the motion.
State's motion and limiting.
You just call him Rashbaum.
Yeah.
As
Yeah.
on the one, Ms. Kappelman.
Wow. It's a losing day for Donna Adelson in court.
Previously, we are moving to exclude Mr. Rivera's affiliation with the gang and any specific prior bad acts as irrelevant and bad character evidence. Did you want me just to address prong one?
Just prong one for right now.
Okay.
I believe at least in the prior trial, this was granted in part, denied in part, specifically as it relates to the defense being able to cross-examine on the issue of bias as it relates to any plea. Are you aware of any authority that would otherwise suggest this is an inappropriate ruling?
No, Your Honor. I anticipate Your Honor would make the same ruling.
Very well. Does the defense have any argument to make as to prong one?
Well, I mean, I think we're gonna have to bring up the Latin Kings. I mean, they inserted it, we weren't able to make this argument in the last trial. His affiliation with the Latin Kings is very relevant as to why and how Mrs. Adelson acted.
Well, I believe it did come out that he was affiliated with a gang, did it not? It's just the name Latin Kings wasn't used.
Yeah, I mean, I just don't want to go afoul of the court's ruling, right? The fact that he is the head of the Latin Kings
Lion Kings?
is a relevant fact.
Didn't he just say Lion Kings?
Might have.
In their
Might
operation, right? The
Sounds
whole-
like Carm talking to
Mrs.
Carol
Adelson,
Baskin.
who is supposedly
Oh
also
my God.
a member of the gang and is speaking on behalf of Mr. Rivera, who wants to get paid, right? And so part of the reason why Donna Adelson acts the way she does and talks the way she talks is because of Mr. Rivera's affiliation with the Latin Kings. I mean, I don't see how we avoid that. Now, as far as his bad acts, I don't plan on going into, just like I did in the last trial, how many murders he's done, how many rapes he's done,
So the name is the identifier, that is what you're seeking to
Of
make
course.
use of.
Of course.
Ms. Kappelman, response as to the use of the name.
By the way,
Group.
1 p.m. today, we're doing the Sandra Birchmore case. 1 p.m. Sandra Birchmore.
If that's Your Honor's ruling, which we would request, then criminal street gang could be substituted for Latin.
Judge, we would disagree with that. I mean, there's a difference between being a member of a street gang and being a member of the Latin Kings. And when Miss Adelson hears that the guy,
As one gang has greater credibility than the other.
it certainly does in Miami, right? So when Miss Adelson hears that the Latin Kings are behind this, I mean, that's what she hears at some point. That's what the evidence is going to be. It affects how she does her,
Jewish gangs.
right?
Oh my God.
And so, we think that is relevant. and that is necessary for her defense.
Very well. As to prior bad acts of Mr. Rivera, the motion is granted. I will also once again permit the defense to explore Mr. Rivera's bias in connection with his plea and any sentence that he has received. As to the specific affiliation with the Latin Kings as being a relevant or probative issue, that goes to explaining the defendant's actions. I'm going to reserve ruling as to that. Specifically, again, in what context beyond hearing she knew he was a gang member are you planning to use this or present this to the jury, Mr. Rauschbaum?
So if there is testimony that she heard he was a member of the Latin Kings and she reacted a certain way, I should be able to confirm with him that he is the head of the Latin Kings. That's it.
I don't think it's a 501c3, but this is a particular chapter that he was in charge of. Is that what you're getting at?
Correct.
Ms. Kappelman.
That's probably
He's
fair.
I mean,
just think
Everett's laughing.
more prejudicial than probative. We don't think the evidence is going to support that she knew he was a Latin king. She knew there were gang members that were threatening to kill, is what the evidence showed in the last trial. So I guess we'll see how things develop. I would request that if the defense thinks the door has been open to that, we approach before they start throwing around the term Latin king.
All right. Generally, as to the issue of Mrs. Adelson conformed her behavior or acted in response to what she believed were the threats of a gang member generally, I will permit that to be offered as a part of the defense's case in chief or any cross-examination. Specifically as to the use of Latin Kings, I'm going to reserve on that issue for now.
And so, Judge, just so I'm clear, before we ask any questions with the words Latin Kings in it, we will approach.
Correct.
Thank you.
This is why Charlie's in South Dakota.
States prong 2. I believe there is no objection on this issue.
No objection, Your Honor.
Prong 2 is granted. Prong 3, Ms. Kappelman.
Yes, Your Honor. Prong 3 relates to Mr. Rivera's mental health status. This has been excluded previously. To reiterate, there's no evidence of Mr. Rivera's mental health condition affecting his testimony at any of the previous trials, nor do I have any evidence that he's suffering from any mental health symptoms currently that may affect his upcoming trial. Obviously, if that changed, I would notify the defense and the court. And there's no evidence that he was suffering from these symptoms at the time that these events that he's testifying about occurred. So I would move to exclude any evidence or mention of his mental health conditions or diagnoses or symptoms.
So, Joel, prong 2 was about some 22 bullets found at the gym. Neither party's objecting to that. That's not relevant.
Right.
We'll discuss it then, but we don't plan on proactively talking about his mental health.
Very well. Prong 3 is granted. Counsel for the defense is directed to alert the court should you believe the door has been opened in a material way concerning this issue. As to prong 4, is there any dispute as to this prong?
No, Your Honor, we've asked for the same courtesy with regards to our investigator, and they've agreed as well.
Prong 4 is granted. Prong 5, is there any dispute?
No, Your Honor.
Prong 5 is granted as well. As to prong 6, is there any dispute?
No, Your Honor.
That's headphones.
Prong 6 is granted. As to prong 7, the demonstrative aids, Ms. Kappelman, you may make your argument.
Demonstrative aids.
This is the video that they made.
Yes, Your Honor. The state has prepared demonstrative aids, which combine video footage, clarified audio recording, and transcripts into one item that we'd like to present to the jury for both the Dolce Vita recording as well as the Matt Surrey recording. So those are mentioned in paragraphs 4 and 6. We also have similar to what we've used previously with the wiretap calls, slides that have the scrolling transcript along with a photo of who's speaking, which we think assists the jury in understanding those items of evidence. I think that was all that was covered in these.
That's right. That's correct.
Dolce Vita, Matsuri, and the wire calls. We did previously have an objection to any editing, any underlining or any highlights, which we have removed from those exhibits. So those will not be present.
Well, response.
Our position is the same as in the last trial. We don't object to the transcripts from the wire. We do object to transcripts for Dolce Vita and Matsuri due to audibility. And last time I think the judge ruled with us and ruled that the transcripts would come in for the wire, but not for Dolce Vita or for Matsuri, and that's our position today as well.
I reviewed the recordings of both Dolce Vita and Matsuri once again. The issue that I keep coming back around to on this, Ms. Kappelman, is ultimately for a recording that does have some limitations or issues. How does the transcript not otherwise suggest to the person or I should say, jurors who need to listen to and interpret it, what is on the recording if they themselves are not able to make it out clearly?
We do have and had in the last trial as well the authentication of the transcript by a party who was present for the conversation. I think that's what made the difference
Meg Donawa.
to the Dolce transcript use in the last trial. We were able to use that. Matsuri was out. The defense is correct on that. That could potentially
Is that witness going to authenticate then the transcript itself?
Yes, Your Honor.
Mr. Rauschbaum, any remaining arguments concerning them?
Yeah, you still can't hear tons of the transcript, and they're guessing as to words on tons of the transcript, and you still can't hear the first 31 minutes.
Yeah, but you have a witness who's going to verify the transcript's accurate.
Minutes, but they didn't include it. So it should be, look, the standard is in situations like this, you leave it up to the juries to hear what they hear. We're actually not moving to preclude the audio, we're precluding a transcript, right? I mean, the law is pretty clear that it's up to the jury to hear what they hear and make a decision based on that and not what the state thinks they hear.
I agree with you, that aspect is clear. The additional portion of the witness who will swear that the transcript is authentic, what is your argument to that?
I mean, but every other word of the transcript is unintelligible. UI. So, I mean, that should not come in. You can hear some of those UIs. Sure, I can cross the witness, but do we really want to go through that when it's very easy that they just hear what they hear? That's the default.
Very well. This will be granted in part and denied in part. As to any transcript for Matsuri, which there is no authentication available by any witness, that transcript will not be presented to the jury. The jury is to determine for themselves what they believe the recording holds. As to any use of transcripts as a demonstrative with the wiretap calls, that will be permitted. As to the use of any transcript relating to Dolce Vita, that will be subject to a proper foundation and authentication being made by the witness. The defense may challenge the foundation and authentication by the witness. However, if the proper foundation is laid at that point, this is no longer guesswork as it relates to the transcript. The parts that are unintelligible cannot be misrepresented in any way. The witness may not misrepresent the parts that are unintelligible. However, to the extent the witness can say, this is what was said during the meeting, that is a proper foundation basis for that testimony, for that evidence to be presented to the jury. That is the ruling as to that item. All right.
Another blow to the defense.
States, prong 8, statements to elicit sympathy for the defendant.
Yes, Your Honor. We had a prior hearing during the pendency of this case where some issues came to light regarding the defendant's allegations of how she was being treated at the jail. I've conferred with the defense on this, who's advised they do think that that type of reference and material would be admissible in this trial. As such, I would move to exclude any reference to the conditions in the jail as irrelevant under 401 and, basically just being offered to inflame the sympathies or passions of the jury and more prejudicial than probative under 403.
Right. What would this be offered for by the defense?
I don't plan on offering it. It depends, though, what comes up at trial, right? So, including consciousness of guilt, because it goes into why someone might do what she did to avoid being in jail, waiting a trial, right? So again, I don't plan on doing it. We don't plan on doing it openly, and we would come to you before we did it, but I didn't want to agree to it because I don't know what's going to come up at trial, right? So it's certainly not going to be something we do without notifying the court first, and I don't expect to do it.
Well, as an important proposition of law, jail sucks. However, why it would become relevant that jail sucks, that's really the question.
Again, as I stand here today, we don't plan on doing it. But if we think it becomes relevant, we'll certainly bring it to the court's attention before we do anything like it.
Very well. Prong 8 is going to be granted subject to any proper or relevant basis in which this evidence could be examined upon. Counsel for the defense at the appropriate time will need to raise why they think a relevant basis has occurred, and ultimately a proffer will be taken as the presence of the jury. And I think that takes us through everything for this morning, other than the other outstanding motion involving Sergeant Corbett. Are any other motions being anticipated by the defense or state concerning the exchange of witness list exhibits?
That did happen, Judge, and we are still in communication about small changes that are happening, and we'll bring it to your attention if we have any issues. But so far, we're getting along okay on exhibits and witnesses. There's still a couple depositions outstanding, which we're working on, so no issues to report at this time. We do want to approach on one other matter, though, before we are done for the day here.
All right. Mr. Morris?
Judge, on demonstratives, and when I say demonstratives, I want to make sure that I understand what you're talking about. You understand what I'm talking about. I've got some flow charts or timelines that I'm constructing. They're not finished or complete yet, and importantly, I don't think they're going to be on Tuesday. I addressed that issue because that's the deadline that we've set. I addressed that issue with Ms. Kappelman yesterday. She indicated that she had similar timelines. We both agreed, with Your Honor's permission, that we're okay not being constrained by the deadline insofar as we share with one another prior to trial. That way, if there are any issues, we're able to discuss those. In other words, no surprises. So the first thing I ask is for your permission to let us manage ourselves, I guess, to a degree. I think that we're in a good position to do that. And what we're discussing as demonstratives are not contentious issues. They're not argumentative issues, I don't believe, on the timeline issues. Second issue is because discovery, because of the depositions, there have been a couple of things that have come up. We're working through those in terms of whether there would be additional motions in limine. And when we approach, you'll have a better understanding of it. But that's basically where we're at. Everybody's working, playing fine in the sandbox together, so to speak.
Very well. I would just ask for a status update on September 6th when we have the next hearing. as to Sergeant Corbett's testimony and his presentation. It's not that I do not trust you all, but I found in the course of my many years on the bench, everyone's saying all is fine until all is not fine.
So it's not, sure.
We'll discuss it on September 6th.
Yes, sir.
You may approach.
So you saw a smile between Georgia and Sarah. They're very happy with how the hearing went today.
Yeah.
You know, the one thing that I think everybody needs to know, you're going to hear all day, balancing test. So what happens in court, you have a rule of admissibility. Is the evidence relevant to an issue? Yes, that's under 401. Then the court has to do what's called a 403 balancing test. Is it the prejudicial value more than the probative? Then the court has to weigh whether, even though it might be relevant, is it too harmful for the probative value? And that's why they keep saying probative value, you do a balancing test, and then judge does that, and then they make a determination. I just want the audience to know what they mean by that.
I believe Judge Everett just said there's going to be a hearing September 6th. Yeah, this is KCL's right on it. September 6th is when they'll discuss the motion limine regarding Chris Corbett's testimony. Believe it or not, September 6th is next week, I think. Yeah.
Yeah, that's the motion, Joel, that I think that the defense has their best motion, because I think getting him as an expert for what he's doing, I don't think he is an expert. And I think their motion may be granted. And I think that's I think the judge wants to look at it, but I think that's their best motion so far I've heard today.
Yeah. Letting us know, KCL, that is next Friday. We'll be back here for that motion. I don't know that Donna will be there. That seems like it'll be a fairly quick motion. We're looking at Donna right now. A lot of comments made about her ears. It's not nice. It's not nice, but it might be true. Her hair obviously much longer. Noticeably no glasses. She usually has her glasses on. Hair much grayer, no makeup. And people have said, and this is not to body shame in any way, but just an observation that is fact, is she has put on weight, a very high carb diets in the jail system. I was telling Tim, I was listening to a news report on the way over to the studio. 6 people have recently died in the Leon County jail for a different variety of reasons. So it is not easy living there. I guess the state is investigating it. Tim Jansen, what is happening right now? Georgia wanted to approach about another matter. If you had to take a guess, what do you think it is?
You know, that's who knows what it could be. It could be witness issues. It could be timing. Both parties want to discuss something. I don't know if there's something under investigation, but they're bringing it to the court's attention. It's not sufficient enough or done completed where they have to file a motion, but I think they're bringing something to the attention of the judge, which is interesting.
We're going to stay on, if Tim will, for a little while to just go over what all transpired today once this is officially over. There's a question already from Cauliflower, like the name. Tim, is Donna going to be able to have her hair done before trial? If not, then I think it might be obvious to jurors that she's been in custody. What is her appearance? How will her appearance change on the first day of trial?
Good question. She'll be dressed in regular clothes. She has the right to get a haircut. My clients, you can get them shaved also. They'll take care of that at the jail. She probably will not be in handcuffs during the trial. They will bring her in and out outside the presence of the jury. So she'll be in regular clothes sitting there. Her appearance, she looks more serene today. She looks kind of defeated. So I don't know. It's a different Donna than the last time we saw her at the hearing, right? She was jovial, laughing and making comments, but now she's,
she looks totally different. I mean, we saw her from the neck up in that Zoom hearing previously. Looked, she looked, like she was optimistic, upbeat. This is a totally different expression on her face today. She does look worn. I think anybody would be who spent as much time as she has in jail. Trio girl, and it's like we're piling on her here, but she looks bad. I would tend to agree, but I don't know how well you can look, in fairness to her, in a prison jumpsuit, completely shackled. at the beginning of this, Judge Everett asking her to raise her right hand, which she really couldn't do because she's got the waist shackle on. So this is definitely compelling. Tim Jansen, we really got our first glimpse today at Alex Morris. I know you know him, a very well-respected attorney. At one point, while Dan was arguing one of his points, I forget which one because I have short-term memory issues that I've just declared. But at one point, he even went up to Dan Rashbaum and whispered something in his ear. I think it was about the trying to suppress the fleeing to Vietnam, his consciousness of guilt. He came up to him. What do you make of Alex Morris overall? He had minimal arguments today. What do you think of the dynamic between the two, between Alex and Dan?
Well, I think one, they made it's better to have Alex there because Alex is local. Alex is professional. He doesn't have that relationship with Donna that seems to be clouding the judgment of Dan. Dan seemed to have a more familiar, friendly relationship with Donna rather than the lawyer client. And sometimes it's bad. Alex is very professional. He'll serve well before the jury. He probably should pick the jury. He knows this community. The judges know him. He's got respect and he's smart. And he's not going to, Dan sometimes said things and did things that you clearly knew he didn't believe what he was arguing. You never got that feeling with Alex, right? He always looked like he had a point. He was making his point, and you more believe that. Dan sometimes like he's talking in a bar between people rather than arguing to a judge, just making these arguments he would make with friends. I think Alex is going to help, but the facts are the facts and the evidence is the evidence. And I don't think you're going to see him take some shots that Dan did during the trial.
Yeah. By the way, even the judge was laughing at points during this, as were Tim and I, but this is not to be minimized in any way. It's a murder trial. It's about justice for Dan Markel. I mean, my own mother, who's a Holocaust survivor, says that humor helped her through it all. So if we make light of it at times, apologies ahead of time. Also, my last email last night, about 1 a.m, was someone yelling at me because I said, if you like the show, please subscribe. And instead of using the word like, it's kind of a valid point since we're talking true crime. I should have said, if you appreciate the show. So if you appreciate this live coverage today, please subscribe to the channel. Please hit the like button. If you hated what you're watching, that's even more reason to subscribe. Hate is a powerful emotion. Tim Jansen's going to be with me all the way through. We have to figure out the dynamic. I am going to be there either right on the first day of jury selection or maybe a couple of days into jury selection, because jury selection is slated to go maybe more than 3 or 4 days this time around. It could go for the duration of the first week. So we'll get up there. Each and every day I will be in court. I'll be in the chat. We're going to be streaming it live on the Best Trials channel. And then Tim obviously is going to be watching it as much as he can because he's interested in it. And then I'm doing lunch lives every day. If I told you how I knew I was going to execute those, I'd be lying. But we're going to be with other content creators, and I'm going to flip on my phone at the Metro Deli where we go to lunch. And I'm just going to do lives and tell you what happened in the morning, what we're expecting in the afternoon, probably like 20, 25-minute lives. And then every night we're going to bring you a full show. And Tim is going to be the lead legal expert on all of that. We're going to have Jared Ross in there. Of course, Stephen Webster's maybe set to testify in this case, but Louis Baptiste and the other regulars that we have on the show, Monica Jordan, will be a big part of it. So this will be the channel for Donna Adelson coverage and the channel for other coverage, as I'm planning to also go to the Sarah Boone trial, which we haven't really touched on yet, but is set to begin in October.
Please contact Lynn about the setting of the hearing for next Friday. Everyone have a good day.
You know, there wasn't much interaction between Alex and Donna.
No. So the judge just concluded proceed. Look at Donna now. Now we're getting a little more. It's a strange look. It almost
She
looks like she's
crying?
about to cry. No, but it's a
Yeah.
smile. It's a
Oh.
weird, kind of a weird aspect.
I told you, what was my prediction? 11:30?
11, yeah, you're 11:14.
Yeah.
Dr. J, who's a friend of Charlie's from dental school, in the chat here. No surgery for him today, so he's here hanging out. Talking about Charlie's pointy elbows playing basketball the other day. The judge just basically dismissed the proceedings for the day. What's going on here, Tim? Are they just waiting for Donna to get taken away to be transported back to jail?
Well, the bailiffs are pretty good here. They'll give you a minute with your client. It's a Friday, so the judge doesn't have any other court. They probably don't have any other inmates in this courtroom, so they're going to give him a few minutes to talk with his client while they're there, and then they're probably going to escort her out.
Tim, people want you to come into the courtroom. I'd love to have you doing this, like on the stream, doing
Yeah.
both, but maybe you can do a
Maybe we
combination.
can do both. Maybe I can come to court one day. And,
Yeah.
I see comments, a lot of people coming. I'd love to come and meet some of the viewers. And
Yeah,
meet them
well,
in person, you know.
just so you know, in Tallahassee right now, we're working on an event that Tim will certainly be at. Again, at Hearth and Soul, which is a big store in Tallahassee. So Tim will be there for that. We're just ironing out some last minute details. We're going to do a couple of get-togethers while we're there as well. Locations to be determined. And we're gonna, also.
You could do some events at my office after. Maybe we'll do like a happy hour or cocktail hour after court.
That would be amazing. And we're gonna get the other content creators to join us too. So it's gonna be a group effort. If people miss this one, I did interview Dan's father, Phil Markel. I've become fairly close with him. And he's almost like a father figure to me now that I lost my father. But I've done the only really full-length interview with him. It's under the video tab on our YouTube page. If you haven't seen it, not because I did the interview, but just to hear from Dan Markel's father is really interesting, especially ahead of this trial. So
Vesper, yes, you're invited to the happy hour. Vesper one love, she was invited to the happy hour.
Vesper Martini's in. Lee Dundee, we appreciate all of you. Thank you so much. So I just want to go over this stuff really quickly. We'll take some questions, and then again at 1 o'clock we're doing the Sandra Birchmore case at 1 p.m. So come back for that one at 1 o'clock today. That's a kind of a horrific case out of the Boston area. So just moving through these various motions really quickly, there was a motion to basically deny Jeff Lacasse's testimony, the ex-boyfriend of Wendy Adelson. Judge said he's going to reserve his ruling on that, although that he's going to testify at this trial. Correct him?
Oh, absolutely, he's going to testify.
There you go. The next one, Wendy Adelson's testimony. They want parts of the book, name changes of boys, Wendy's willingness to allow the grandparents, meaning Ruth and Phil, to see the kids, grandparents' visitation rights. They wanted a lot of that left out of the evidence portion of this trial. I forgot to make a note about how he ruled on that. Do you remember, Tim, about how he ruled with regard to Wendy, or did he reserve ruling?
There's parts that he ruled he'll reserve, some he's going to come in. I mean, the takeaway from today was really that the defense really didn't get anything they really wanted, right? They didn't get to move the courtroom. They didn't get it dismissed. They didn't get the evidence going to be kept out. He did reserve on parts of that. So while they're making the motions, which they have to do, okay, Nothing is going to really change the government's case and not going to change the defense's strategy. So I think we're going to see the trial that we thought we were going to see, and we're going to see it in the big courtroom, because I know a lot of people were mad that they weren't going to come now, and I hope all the viewers come and see. You're going to see a good trial. You're going to see a great judge. And it's so different than the Karen Reed case, because you have a judge here who rules on the law, applies the facts, gives parties both sides equal time, and makes rulings, unlike the Karen Reed case, right? So
Yeah. By the way, a very informal poll here. You can email us at survivingthesurvivor@gmail, or let the COE know in the chat. But we're ever evolving. This is what's so interesting. You know, I was in broadcast news for 27 years, and you're told what to do, but here we can do things our way. So one of the things that the COE, Steve Cohen, and by the way, shout out to Space Coast on the West Coast, who is helping immensely with the audio. There were some audio issues on the other, not on his end, but on the pool camera today. So shout out to Space Coast for fixing that. And of course, our mods, who are amazing. But the informal poll is, I am a news guy. I'm not an attorney, but would you like to see more breaking news on STS? In other words, when there's a verdict being read in the Robert Tellis case, even if we haven't covered it extensively, do you want me to hop on and talk about it? When there's a press conference related to Sandra Birchmore, do you want me to hop on and be live in addition to our shows in the evening? That means I'd have to have my behind nailed to this chair all day, but I'm willing to do that for STS Nation. And again, we are going to be going to trials and covering more trials this year live. We are following Shanna Gardner closely. Alex is asking. We've covered that case closely. We'll cover future hearings, but let us know what you think about hopping on to do more lives. More work, but the COE, Space Coast, and I, and Steve Cohen are enjoying all of this. You can obviously subscribe to YouTube, and we've got our Patreon page going. And I have gotten my Edvard Munch, The Scream, up right behind me, which I love. Subtle, but behind me.
are you spending weekends, Joel? Or are you going home?
I am, because I'm driving, and I just not going to have. And by the way, I think we're going to be doing that Hearth and Soul, which I'm going to talk to you about the first weekend.
Well, we can have a pool party here, and I'll barbecue at my house.
I love it. Yeah, let's do that. Let's definitely do that. So the other motions, just super quick. I mean, they tried to deny autopsy pictures. That was denied. A motion to preclude travel as consciousness of guilt. I mean, Donna was looking up travel to Vietnam and trying to get there as quickly as possible, looking up non-extradition countries. So that was denied. That will all be allowed in. Luis Rivera's gang affiliation, part of it, he's going to reserve a ruling on that. Demonstrative aids, video and audio for the Dolce Vita and Matsuri will be allowed, but the transcript for Matsuri is not allowed. Transcript for Dolce Vita will be allowed. So all these things that are kind of the minutia of this case. Tim, just run us through, because I'm not clear on this myself, the whole issue with Sergeant Corbett coming up a week from today. What is really at issue here, and how do you think this judge is going to rule on it?
So it's a great motion because they took the deposition of Sergeant Corbett, right? And in order to be an expert, you have to be an expert in something. You can't just do menial work and get the mantle of an expert in before the court. And that's what they're arguing. All he did was look at some things, and now he's testifying, and he's only testifying, and he built this chart, only what the government wanted him to do. That doesn't make him an expert. That makes him an administrator. So they don't want him labeled as an expert, which I understand. I think the court's going to rule favorably to the defense. He's not an expert for that part, right? And then the summaries, she wants to put all these documents into what's called a summary exhibit. That can be admissible because you don't want a jury to have to look through 1,000 records for 4 phone calls. But when they deposed him, they said, well, how did you come about this summary? He goes, well, whatever the government state wanted me to do, I put in. Well, that's not really a summary. It's more like a closing argument. I think they're going to win on that part also. It wasn't just a summary. It's a, basis that the government's position, and it's not a summary. It's more an argument. So I think the court wanted to see the deposition, wanted to see the summary charts, and I don't think they had them for the court. So I think that's why he's going to rule. And I expect him to rule in favor. He's going to say that Corbett can testify what he saw, but he's not going to testify as an expert. And I think it's a good defense.
Yeah. Walk away Renee here took me. These are, like I said, like reading license plates sometimes, these names, but I like the name. Tim, a couple more questions and then we'll wrap it up, I promise. Tim, do you expect any more rulings on these proceedings to favor the defense once the judge has considered them? You just obviously talked about Corbett a little bit.
No, I don't think they will. Usually when a judge, and it goes both ways, right? I've had hearings where I knew we were going to win, and the judge didn't want to rule in front of a full courtroom, didn't want to make the government or the police officer look like a liar. So he reserves ruling and does it by order. But I don't think that's what's going to happen in this case. He's going to look at some cases, and he's going to, I think the case law is pretty what the government argued. These prosecutors are not two that are going to give the judge bad case law. They don't want to jeopardize a conviction. And you could see that when they were giving deference to some things that were against them. So I don't foresee anything changing that's going to be a massive win for the defense or a loss to the state. I think the state's very comfortable now. They know what's coming in. There's a few things they have to ask the judge before they do. So that's the professionalism you like to see in a trial. So parties, and that's the best way. Because if you're picking a jury and doing an opening, you want to know what's coming in because it affects your opening. You don't want to say something in opening that the judge rules can't come in because then you have no credibility. So both sides really want to know, and the judge doesn't like to get hit by surprises. No judges like that.
Space Coast, look at this, gifting 5 memberships. He is the audio king. Space Coast on the West Coast. What about this, Tim Jansen? Mish, who comes to us from Cape Town, South Africa. Lest you think we are not a global show, can they talk about Charlie being convicted in this trial, Tim Jansen?
Well, I think it's fair game if Charlie comes in and says his same story that I told my mom. And, well, Charlie, you're a convicted felon, right? And you're convicted of this from this same story that you just told this jury. I think that's fair game for impeachment, right?
Yeah.
He's opening the door by giving this story, and they're going to impeach him. So I think you can.
Look at this. It's from CBO. You're the best, Tim, followed by KCL, who really knows her stuff. Tim, you're a class act, and we love you. I'm just scrolling through here to see if there are any more interesting questions before we say goodbye.
KCL, we got a pool party in Tallahassee if you want to come.
Come on by. You got to come out from Utah. KCL is just following up here. What about the defense saying some of those slides in Corbett's testimony are hearsay, Tim?
Some of the I wish you could tell me which ones. I'd have to see what they are because, they may be hearsay. But even if it's hearsay, that doesn't mean it's not admissible because there's hearsay exceptions, right? And if the defense opens the door and for impeachment purposes, they can come in just like the Wendy Adelson did you say about hiring a hitman? Well, that's hearsay, but she denied it. So then they brought a witness in to impeach her, which is, they called it backdooring, but it's relevant and it's true.
Yeah. Abby is saying, look, he's going to be, is this true? Is he going to be in a prison jumpsuit when he testifies?
He will be.
Yeah.
He does not get any benefit. He is not on trial. He's merely a witness, just like Luis Rivera testified. Yeah. He was in his jumpsuit.
So, and Katie McBana was. So it's going to be pretty obvious when he comes in. I was just thinking about this. Tim, is he in any kind of danger in the Leon County jail? Because he's back in Florida and he's going to be here for a while. Do they have him on total lockdown? Look at this. Look at this, Tim, on a plane over Kansas City. Fly safely. It's amazing that you can watch this on an aeroplane. Go ahead, Tim.
He will be in seclusion. He'll be in a pod, and they have pods where you can't leave that individual pod, your room, without an escort. And so he'll be in full what do you call it? Segregation.
I'm looking at this. A lot of people are saying yes to the breaking news. So this is a group effort. I like to include STS Nation in everything we do. So if you guys, we keep a calendar, but we obviously look, when I was one of the first producers at MSNBC, hired and ended my career at Fox News. So I did the whole political spectrum. But the point I'm making is, at these cable outlets, networks, there's literally hundreds, if not thousands, of producers. And we're doing it with 4 people. So I beseech you, if you guys know of a big hearing coming up in a case, or a news conference set to be discussed. There's so many stories going on in this country. There are 3 missing kids right now. I think they're still missing in South Carolina. There's a couple that just disappeared from a nudist colony in California. An arrest was just made in that case. My point is, there's a lot of things going on in a lot of places. So please flag us if there's something you want us to cover as breaking news at survivingthesurvivor@gmail.com. And maybe the COE and Space Coast can come up with a better way to communicate this. But I'm a guy who was born without a cell phone, so I don't know how to use Discord and any of that other stuff. And Space Coast likes to make fun of me. Go ahead, Tim.
So Joel, 2020 is obviously going to do. They're contacting me about doing an interview with. They're going to do a show before the Donna Adelson trial, and if I get a date and time for the airing, I'll let you know, and you can let everybody know. But 2020 is going to do another show on the Adelson, and my understanding, they're going to have all the jail calls, and I'm going to do the emails and jail calls. That's one of the parts I'm going to be covering.
Nice. And Dateline's obviously doing. They're going to be doing another show. So this is a very, very high profile case. Yep. I had been talking a little bit with the family, with Ruth and Phil, and obviously our focus should also be on them. They're, every time this is retried or tried again, I should say, in a court of law, it impacts the families greatly. It's very high stress time, a lot of worry, a lot of concern. So please keep Phil, Ruth, and Shelley in your thoughts and prayers. And obviously there's the family now. Look at this. Dr. J had a baby. I did not know. Oliver, love the name. The infant, has asked Jay to buy an STS onesie for him. The work never ends at STS. We are also working on improving the merch store, which is somewhere in the ether sphere. But COE, let Jay know. By the way, COE, Karma's also screaming that she has not gotten the newsletter. If anyone wants to be included on the STS newsletter, again, email us at survivingthesurvivor@gmail, and we'll get you a newsletter.
No, don't email.
Oh, what? Do what? Thank you. What?
I can't respond to 2,000 emails. They can sign up. We're going to put it right here. We'll also put it in the show description, but there's an area where they can directly sign up for the newsletter.
Where is that area?
It's in chat right now. If you go to chat, you can find the link to sign up for the newsletter. We will also add it to the show description, and we will also add a link on our YouTube channel that makes it easier for everyone. Thank you.
Yeah, you've got to click on this here to sign up to receive the monthly newsletter. I'm with KCL here. I'm a student of Tim Jansen's in STS Law School. I'm learning every day. In news, you have to kind of pivot. I covered politics. I covered U.S. equities on the floor of the New York Stock Exchange, and I still don't know what they are, but I made it seem like I did. But this, to me, is the most fascinating of the things I have covered, and I'm really enjoying it, partly because I'm the child of a therapist, a licensed therapist. My mom and my dad are psychiatrists, and I just never understand why the hell people do these things instead of just getting a divorce attorney. Tim Jansen. There's been a lot of confusion, but I've confirmed this with Ruth herself. Look at this. COE. Daniela Medina would love to help with the merch store. She's local in Miami. Daniela, if you see me, I bought custom, not a license plate, but a license plate frame that says Surviving the Survivor, Best Guest in True Crime. Come knock on my window.
Hey, Joel, well, I want to get cufflinks that say STS, and I can wear them because I wear them every day when I'm in court.
You hear that, Daniela? COE, can you please get Tim Jansen STS cufflinks? That's what we're gonna have to do. Now we're going completely off the rails here. But anyway, I did speak to Ruth. There's been a lot of confusion about when this is actually beginning. So jury selection starts Tuesday, September 17th. Tuesday,
Right.
September 17th. That is 2 weeks away, ladies and gentlemen. Steve Cohen and I are going to be driving up to Tallahassee once again. And look at this. Ned Smith wants an STS dog collar. We got to make it happen.
Joel, I meant to ask you.
Yeah.
I have connections to a box, so I might be able to get box for that game if you want to go to is it California game?
Yeah, I absolutely love that. My good friend Jared Ross had mentioned something, but we'll coordinate.
Okay.
But
right.
Either way, I'm going to that game, even if I have to break into what is the stadium called?
It's Doak Campbell Stadium.
Doak Campbell?
DOAK.
Oh, Doak Campbell. Okay,
Yeah.
well, breaking into Doak Campbell if I need
No,
to.
we'll get you in. A box is better. It's air conditioning. They have refreshments.
Got to know the right people in life. It's not what you know, it's who you know. And I know Tim Jansen and Jared Ross. So Tim, very quickly.
Yeah. 23rd is the date of trial, though.
Well, jury selections begins the 17th.
The trial is starting the 23rd. That's the order I saw from the judge.
I think that's a rough estimate as to how, because they're expecting.
Okay.
I mean, Tim, is it true? And then we'll wrap up. But is it true that with each iteration of these trials, it's harder and harder to seat a jury in Tallahassee? Is that your understanding? Is that why they're saying it's going to take longer for the jury selection?
That's fair. That is fair to say. Yeah, and it's interesting, because this trial is going to go on while the students are here, and you have some students that have registered to vote here, so they could. I don't know if they registered to vote here, whether they can be called as, but you're certainly going to get local students. So, and we have 3 universities here. People don't forget that. We have FAMU, we have TCC, and FSU. And that increases the population in Tallahassee about 90,000 from one summer.
Yeah. So KCL again. I mean, I think the 23rd is like the target date. It depends.
Right.
And you see Abby here saying jury selection is starting. Nope, that is incorrect. Starting September 17th. There's no confusion. It is September 17th on a Tuesday because there's something else going on that Monday. So jury, even we're confusing you, but it will be September 17th. That is coming directly from Ruth Markel to me. And
it's in the big courtroom. That'll be great. More people can go.
Might want to check that 9/17 date. It may have recently been, unless it was moved, but I just talked to Ruth literally a day ago. So unless it was just moved, I don't know. There you go. I mean, a lot of people are coming. Tim, just very quickly, your final thoughts here on what to expect with jury selection. What are you sort of anticipating the most with just a couple of weeks away from this trial getting underway?
Well, I think KCL made a great point in the chat. Tallahassee is getting a lot of new residents moving here. They're moving up from South Florida. They're moving from other states for tax reasons, for weather reasons. So you're going to probably get some potential jurors who have been here like 3 years ago, that may not know much about the trial, certainly the earlier trials, who might come in and say they really don't know anything, right? Because if you get someone local that lives in the Benton area where the murder took place, it's going to be hard for those people to say they haven't heard anything. And that's why Alex will be helpful. He knows the neighborhoods. He'll know. That's going to help so much better than some jury consultant. That was a major mistake. And having Alex, I think, is going to give the defense more credibility. So,
here's a final question. Do you think she has, Donna, plausible deniability in believing Charlie's extortion theory. Tim, the way I understand it, they're gonna have to put her on the stand, and she's gonna say, look at this. I wish Joel would write a book. I'm not allowed to bring it up. So Abby, thank you so much. Surviving the Survivor, 10% my mom's Holocaust story, 90% she and I screaming at each other and her giving life advice. The book will really change your life. I guarantee you that, or at least make you laugh and cry. And everyone needs some of that. But Tim, back to that question. What's the defense going to be here? That she was just protecting her son. She didn't really know what was going on. Are they going to go so far as to say that she didn't even really know about this double extortion, but she was just aiding her? I mean, I don't know how they can do that based on all the wiretaps, the jailhouse calls, all these things. But what do you think in a minute or two, what do you think this defense is going to be related to the double extortion?
It's going to be Donna didn't know anything, that Charlie came to her, told her what had happened, and that's why she was talking in code, said you have to pay Katie Magbanua. That's why she paid. And that's why when the bump came up, she called her. She trying to protect everybody. So I think that's what's going to be. Donna knew less than Charlie knew. And that way he can do it the same story. And they're going to hope that break will be enough for a not guilty.
There you go. I cannot thank Tim Jansen enough. Love the guy. Such a gentleman. Great guy. Great wife. Great daughters. Great house. Great dogs. Great dogs. I was getting great dogs. Great Christmas decorations. It's just Tim is awesome to be around. Great sports car. Yeah. Antique sports car. It's good to be Tim Jansen. Tim, I'm going to see you in just a couple weeks.
I can't wait. Yep.
Yeah, can't wait. Love you, America. Thank you, STS Nation, for being here. Much appreciated. We're taking a 1 hour break to hydrate, and then we're back on the main STS channel for 1 p.m. live on the Sandra Birchmore case, which is really disturbing. Tim, we got to get you on that because there's a federal prosecutorial nexus with that case. I want to get your take on. We're going to be doing it next week. Tim's taking a call. I'm saying goodbye. Love you, Tallahassee. Justice for Dan Markel. And see you at 1 p.m.